49141. Your name, sir?
Anthony. Anyone else here?
Good morning. You're charged with unsafe load. You have the right to an attorney. Would you like one?
No.
I'll go ahead and arraign you and then I'll let you go talk to the prosecutor, okay?
Yep.
It is alleged that on October 29 of 25 that you did operate a motor vehicle on I-75 northbound near Vreeland in the township of Brownstown at 8:59 p.m. They think you had an unsafe or improper load that is misdemeanor, punishable by up to $500 fines, 90 days jail costs, or all of those penalties. Do you understand that?
Yes.
Did you sign an advice of rights?
Yes.
Did you read it and understand it?
Yes.
You plead guilty, you'll be giving up all those rights, and we're not going to have a trial. You understand that? All right. You still wish to waive your right to a lawyer?
Yeah.
I'm entering a not guilty plea. I'll give you a personal bond. You don't have to post any money. $500 personal bond, but you'll owe the people of Brownstown $500. If you violate any of these terms, you cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand all that?
Yes.
All right. Do you have any questions? Go out in the hallway. We'll take it to the township attorney and she will call you in.
Okay.
Thank you. Either way, you're coming back in front of me, okay?
Okay.
Do I dare call this case, Mr. Boyd? Robert Thomas Boyd, 25B82557, calling the Penn City Attorney opposed. Township Attorney.
Morning, Tom.
How you doing, Mr. Boyd?
Pretty good.
Your name?
Robert Thomas Boyd.
Okay, so I'll give you a lawyer if you want one. This,
Thank you.
you waive your right to a lawyer?
Yes.
You're here for a review hearing. Please tell me you did something with the property.
Oh, yes, sir. I got a big trailer full of stuff out of there.
Did you?
Yeah. A big trailer. 6.5 feet high, 8 feet long, wide, and 8 feet long.
Did you get everything out of there?
Not everything.
No, no.
He's supposed to bring me another trailer when he dumps out.
I know, but did they take the whatever debris you put in the trailer and remove it?
The guy's taking that out of there today.
Good morning, Your Honor. Caitlin Boyd, Carter, Brownstown Township.
Ah, so I said, do I dare call this case? What have they done? Go ahead.
Sure. Orders enforcement officer Rob Harris went by the property yesterday. He advised that the dumpster was full. The garage, trailers, boat, cars, junk, and debris were still evident from the street. He did go into Township Hall and obtained a demolition permit application. However, he's never filed that, nor has he gotten a demolition permit.
Well, I don't need it, Your Honor, until I get ready to demolish it. I'm pulling everything out of that garage, the cabinets and all that stuff. So when I demolish it, it'll come down easy. So I didn't know if there was a time limit on the demolition permit. Is it?
It's right.
You don't know? Oh, she don't know either. He's supposed to bring me back another trailer today.
You gotta move a little quicker here.
Well, that's a lot of work.
We've been talking about this. You were issued citations quite some time ago.
Yeah.
And this citation was issued in April. This is November. How many notices did they send prior to that again? How far back does this whole issue go?
The property itself is, the ordinance violations have occurred since 2001.
Okay. So last I looked at the calendar, it's 25, right? I wish it was 2001, but it's not. Please. I don't want to have to send you to jail again.
I don't want to go. I got too much work to do on that.
I know, but you gotta move faster. Please?
Getting help would help a lot, but it's hard to do.
If I may, Your Honor, I did, last time we were here, a Good Samaritan knocked on my door and advised that they were there because they wanted to help Mr. Boyd. My understanding, she received the phone number, his phone number from one of our hearings. She tried to make contact with him multiple times, left multiple voice messages, and he never returned her call. She is interested in finding help. He just needs to connect with her.
With,
Her name's Adrian. She left you a couple voicemails.
she did,
She did.
she wants to help me,
She does.
she's gonna let that heavy stuff.
She has a whole bunch of people that want to help you to stay out of jail.
See,
I didn't get them.
Mr. Boyd, listen to me. I have felt awful sending you to jail, but I have a job to do here. And I'm going to do my job. I don't know what else to tell you, sir. You gotta move. You gotta get this stuff out of there once and for all, for your safety too. All right, here's what I'm doing. I mean, I don't think she would tell the prosecutor she called if she didn't call. Probation is extended. I'm extending your probation. Probation's extended until, but this doesn't mean you have this long to do this. Do you understand?
Yes, I do.
To July 30, to July 30 of 26. No probation fees. Lisa, please give me another review hearing date sometime in early July.
I'm looking. Hang on one second.
Take your time. I'm going to set another
July 1st at 9 o'clock.
at 9 o'clock. And I'm going to give you another review hearing date to come back in front of me, but I want all this stuff going. Listen to your voicemail. Call the lady if she's willing to help. Or your sons, I don't care who you get. Sir,
If Mr. Boyd wants to
Yeah.
be in the conference room, I'd be happy to give her.
sure. Now listen, I don't care who does it. You know, ultimately it's your responsibility, but I can't give you much more time. And I know you're going to start telling me the weather, but you should have done it when I told you to do this. Lisa, give me something the second or third weekend, a week of July or January, please.
January 14th at 8:30.
That's your new review hearing date. So the other one, the July date is to dismiss the case if you're compliant.
Okay,
This is going to be another review hearing date, January 14th. You got to get going. You got to call that guy, have him empty that, give you another dumps, whatever you got to do.
I understand. I would just like to reiterate that I think our biggest concern is still the dangerous building.
Of course it is. It needs to be,
everything on.
Mr. Boyd, come on, man. You're such a likable guy, but you're killing me. You know that? You're going to make me do something again that I don't want to do. I already had to do something twice that I didn't want to do. Come on, please. Don't do this. Get this stuff, get that all taken care of by January, and we all can all go on. I'll buy you lunch. You and I and the prosecutor and the building official go out. I'll buy lunch. Take care of it, please. January 14th. Thank you. Have a good day.
Thanks.
Ricky Floyd Parker Jr., 25B1493998.
Morning, guys.
Good morning, Mr. Youngs. Give me 1 second here. Your appearance,
All of them's gonna be at Rick.
sir, your name.
Ricky Parker Jr.
All right, I need to ask, is anybody here from Granite Televalley? Anybody here from Granite Televalley? You are? Come on up here, please. You can go right to that microphone. That is a microphone. You don't have to walk in that's a microphone, believe it or not. Can you come around this, there you go. Come on up a little bit further so you're speaking into the microphone. Your name, ma'am?
Suzanne Bryant,
And what is your position with Granite Televalley?
community manager.
Okay, so you're here, appearing here to make a claim for restitution or a statement?
That's correct.
Did you file, you have a piece of paper? Do you have any out of pocket?
Caitlin has, I haven't done anything yet because of the season. We would have to do it next season. So he took down a cherry tree and a fence. And so there's an island in my community that cherry tree was in. And it's probably about 6 feet wide, and if it's that wide. The bulb of the tree that he took down, most of it is still in there, and you have to have a backhoe come in and dig out the thing and then replant a 15-foot cherry tree. They don't feel $2,800 to do that and replace the fence. They believe that's too much money.
Who does?
We do that.
His attorney.
Well, you haven't been communicating with his attorney, have you?
No, Caitlin has.
Call in Caitlin. $2,800, how tall is the tree? Let's talk
It's
about,
about 15 foot. The bulb, the root that we took out was about this big around, so the rest of it is in that ground.
want to get alternate estimates?
Well, I said they could plan, I don't care, as long as.
Might be able to go to his insurance company.
I don't know if they cover that, but
Why?
It's probably
it
James.
just sounds so unusual. I hadn't really thought about it. We initially just,
What about the fence? What kind of estimates you have on the fence?
$380, it's a split rough fence, it's not an expensive fence.
the fence option was,
All
I
right.
saw 2,500 for the cherry tree.
Have you had a tree cut down lately? I've had trees cut down and they are not cheap.
No, I think they need to dig it out. It's the expensive part.
Well, okay, but you gotta have an option, not just, I think it's too much. Is Foley Carter your name?
Caitlin Foley, Carter, Ross's Township.
So what kind of restitution? Did you talk to Mr. Youngs about the restitution?
I did, and I provided the estimate that Ms. Bryant.
Is that from a tree company?
It's from a maintenance company.
It's for the cost of both the tree and the fence.
I know, the fence seems like it's minimal, it's $380 or some such. Do I have a copy of that estimate?
I don't believe so, Your
I
Honor.
doubt it, Judge.
Can I have one?
I can look at one.
Okay.
And Your Honor, I don't care who does it. I mean, they can hire whoever they need. I just want it restored.
No, that makes sense. I mean, you're entitled to have it restored. You're entitled to be in the same position, so you can't. All right, let me just get this estimate from her and we will go from there, okay? Did you call any tree removal companies?
I did, but, it's trimming season and they said that they could get to me at some point in time. I have a tree company coming in next week. I could get another estimate from him.
Well, this is 2,500 for the tree. That includes the tree and the fence. So I mean, you're looking somewhere at the rate of about $2,500, I guess is what they've got here.
I thought it was 2,500 and then 300 additional for the fence. What's in the $2,800, John? Or am I?
Yeah, but I thought you guys were talking like 2,800 for just the tree removal and then 380, I thought you said. Did I misunderstand you?
It's 25 for the tree and 380 for the.
I only see 300 here on the replace
300, I don't have it.
split rail fence.
Yeah.
All right, well, let's do this. I'll set a restitution here. You guys can make a claim with your insurance company. You can coordinate with the prosecutor. You can send out somebody to,
Take a look.
get an estimate on that. You want them to grind out the stump too, right?
Yeah, everything's gotta be removed.
I mean, that's a job too. It's just not surprising.
You look at the estimate, you know, you just say, oh, a cherry tree. And I started Googling cherry trees and they're not even $500. So you know, it's a little bit of just, we need to.
I've had trees cut down and I'm telling you.
Well, it's also saying removal of whole tree. We didn't realize that was part of the gig. Or at least maybe.
You want them to, you just want them to, you want them to replace it or you want them to remove and replace
I
it?
want them to remove because I want it in the exact same spot. That's the only place it can go. So that the rest of that root has to come out in order to plant a tree.
You'll be lucky to get away with $2,500 to remove that, put in a similar tree. All right, let's go on with the sentence. I'm gonna listen to whatever else you have to say. I'm gonna set this for a restitution hearing. We will talk about when that is going to be at the conclusion of the sentence. That will give people an opportunity to do their research, okay? So, have you had a chance to review the report with your client? Is that okay? Or
Yes.
do you want to say anything else before you sit down?
No.
Do you want to say anything?
I did complete a written impact statement that should be in the file and attached to the estimate.
Okay. Let me just, yeah, I see that. Okay. Good enough. Anything you'd like to say? Is everything in this report accurate? If you want to say something else, you can. If you don't, you can have a seat and we'll give you a restitution hearing date here.
Yeah.
Everything in the report accurate?
Yes, Judge.
Anything you'd like to say on his behalf?
Just that he's been very proactive. He wants to get going probation, even with respect to this restitution issue. He said, I hope we can at least get going on the probationary requirements so I can get him moving and, you know, hopefully be out of the way. So looking forward to playing ball and doing whatever this court asks him to do regarding the conviction. That's all I have, Judge. Thank you.
Sir, is there anything you would like to say?
I apologize for my actions and I accept the consequences to ground. Thank you.
Do you have his AA verification?
Yes, sir.
You can just show it to your lawyer. Has he been going at least twice a week since October the 8th?
Yes, sure. Sure looks like, Judge.
Okay, so he's got at least 10 or 12 on there. Okay, oh, okay.
He was gone before the rain, but I just glanced at it and I see 11-8, 11-9, 11-10, 11-12. So the frequency seems to match up with what we've asked for.
So I don't think I have to tell you how outrageous this was, right? I mean, you drove off the road, you ran into a fence, you ran into a tree, you had way too much. You had 3.5 times the legal limit. 18 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs, and ETGs bi-weekly for 6 months. If you're clean, I'll then revert it to monthly. You're to remain on the SoberLink device until February 15th of 26. So we're going to set a restitution hearing. You are to pay, defendant to pay restitution after hearing as determined by the court. We'll give you that restitution hearing. We'll talk about the date on that as well. You're not to enter Granatella Valley Mobile Home Park. You're not to enter there at all. AANA 3 times a week until an intensive outpatient. You're going to go to intensive outpatient. Once you get into intensive outpatient, you can stop going to AA. You're also going to attend the victim's impact pain. I believe I've covered everything except the court work program, and I have to have you do 6 days jail credit 1, serve 5. I'll let you serve those on the court work program, 5 days court work program. There's $175 a day, $175 charge for that. It's $35 a day, 300 fines, $250 costs, 75 victim's rights fee, $50 justice assessment. So fines and costs here amount to $675. You have a screening fee of $60 for $735. You have cost of recovery of $225 for a total of $960. Probation fees are $360 for a total of $1,320 plus your court work program fees. Everything included amounts to $1,495. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You'll have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I don't know how to put this to you, but you got to be careful. This is crazy. Okay?
Understood.
You may be eligible for early discharge from probation if you're compliant after half the time. This could have been worse. We're setting a restitution hearing. How long will it take everybody to get their figures in order? Why don't we just set it at least after the first of the year, and that'll give you a chance to save some money.
Sounds great. I was gonna say 12/17 is, but I was just looking at my calendar. If we wanna,
We'll do it after the first.
okay.
Unless
January
you
4th.
have a problem with that. Let's go to like this, my first or second docket, like the second week of January with Brownstown.
Jan- January 14th at 9 o'clock.
January 14th at 9 a.m., okay?
Take them down to
Probation, can he pay all this today?
these, I asked him if he could pay 200 today. Are you able to pay?
300.
You get paid weekly, right?
I get paid bi-weekly.
Bi-weekly, how much can you pay bi-weekly then? No, how much can you pay bi-weekly?
About 125,
I'll make it 100. When do you get paid next?
2 weeks from today.
Okay. Keep-
No, 2 weeks. The check comes in usually Wednesday, Thursday.
All right, let's do this. You pay $300 today. You pay $100 bi-weekly. And I will start that beginning on December the 8th. If you need more time, all you have to do is call the court. If you don't have the money before the due date, I'll be glad to give you an extension. Just don't be fearful or nervous, because I don't care how many times we have to do that. What I'm not going to be nice about is if you don't call the court and if you don't call the court and get permission to get an extension. And again, I don't care how many times we have to do that. Actually, I'm only going to have you pay 100 on the impaired charge today, because I'm going to have you pay the fines and costs on the B file, $200, okay? So you'll pay that one today, the civil infraction of refused PVT, and then $100 down on the impaired, and then $100 bi-weekly starting December 8th. Anything else?
Cashier first on probation, Judge?
Yes, sir. Thank you. Have a good day. Good luck, sir. Thanks a lot, Ms. Bryan, wherever you are. Jonathan, who's your lawyer, Mr. Johnson? Mr. Baldwin? Okay, we're gonna have to wait for him to come in here, okay? Derek Paul Lopez Jr., 25B149536A, and B and C.
That's Mr. Baldwin's also.
Okay. Yeah. Sir, I'm sorry, you're gonna have to have a seat behind you there, okay? Naya Lene Thomas, 25B1489443A.
Morning, Your Honor.
Good morning. How you doing, Mr. Granata?
Good. Peter Renato, representing Ms. Thomas. This is the time and date set for the sentencing hearing.
Your name, ma'am?
Nine Thomas.
All right. Have you had a chance to review the report with her? Are there any material additions, corrections, or deletions?
I know you're okay. But we would like to speak to a couple of items on the report.
Okay. What would you like to say?
First, we would like to, on number 4 in the recommendation, it says that she shall not frequent any place that serves alcohol. Ms. Thomas is a bartender part-time, and we would like the court's understanding that she can continue to work as long as she doesn't frequent that establishment or any other establishment outside of work hours.
Okay.
The second thing is that because she lives about 30 miles from court, we would ask the court to, instead of a work program, if you would consider doing a community service.
Is this called Night Owl Bite Club? Did they spell this correctly on here?
It's Night Owl. I don't know what it looks like.
Night Owl, NITE? Yes?
Yes.
I heard everything you said. I'm not sure I can go along with it. Anything else?
No, well, other than the fact that, Your Honor, she's only working part-time, and so therefore, and she's obviously qualified for indigent counsel, so she has very limited income. And so the fines that would be assessed and the costs for her probation are going to be possibly more than she can afford.
You've got a bachelor's degree from Florida A&M.
Yes.
Why are you working in a bar as a bartender and then going out? This is crazy. This scares me. Does it scare you? You have a 311 on the breathalyzer, young lady. You're far too smart to be doing this, right?
Yes.
Do you know how high that is? I mean, I guess now since COVID, everything's high. I don't know what in the world's going on out there, but it scares me that you're still working in a bar. And it bothers me that you are living with your parents, and that's good. I guess you got a son. Is the father in the son's life?
No.
Collect child support from him?
Trying to, but the case is kind of going on and it should be.
Where does he work?
I believe he just got out of jail last month.
Nice. Well, what's a smart girl like you doing with somebody like that? I mean it. I want to have a conversation. Why are you allowing someone who goes to prison to father your child?
I think like when we got together, like we were in high school, so he was kind of young and he's still young minded. So I mean, people change once.
Okay.
And
Well, what do you go to prison for, out of curiosity?
what do you got?
Prison for?
That I'm not. I believe it was something he did at school. Like he was at school and then he violated his probation at
I don't go to prison. If you mean prison, you mean prison. You said prison, didn't you? I thought you said prison. Okay. You've been going to AA. Let me see your AA attendance.
Yes, sir. She's gone,
She's been gone 4 times since November 5th, so at least 6 times, 5 times. Fair enough. I trust you, Mr. Granada. Take that back. You on the sober link? You blowing into that? You have any positive blows?
They haven't called me and I don't know if I've had to drink since.
Okay, so because, I mean, to me, you seem like a really nice lady and you're not acting like it. You're just not acting like it. I mean, you've got an attempt check, no account. You pled guilty to back in April. Retail fraud, you pled guilty to back in April. You got a bench warrant in Pennsylvania for shoplifting. got to reevaluate.
Yes, I called.
I'm shocked that you weren't vomiting long before you got to a 3-1. The overwhelming majority of us would be vomiting well before we got to a 3-1. I'm not trying to make you feel bad. I'm trying to make you reevaluate where you're going with your life. You can continue on this path and it's not going to be a happy life for you. It's just not. If you continue on this little excursion that you got going here, am I making sense or not? Am I just an old man that you just don't, he doesn't understand? I
No,
mean,
you're making sense. I just feel like, well, the Pennsylvania charge, I was taking care of that.
I don't want you to talk about that because you're still not convicted and I don't want you to say anything against your interests, so.
And the conviction from April, the conviction from April was something back in 2020. So I was just recently out of high school and that was something.
Why'd you wait until 25 to take care of it? You didn't show up in court?
I had moved to Florida, so I went to school. I didn't know I was
Did any-
supposed to be going to court and I had paid the warrant and then I didn't know I was supposed to be going to court
You
after.
got a bachelor's degree.
Years.
I mean, come on.
I mean, that was my first time. I didn't know I was supposed to be going to court after I paid for it.
You get what I'm saying. I'm not trying to quarrel with you. You got a bachelor's degree and you are acting like a criminal right now. And I hate to say that because you seem like such a nice kid, to be honest with you. But you can't do this. You want to do this, it's just a ramp to unhappiness. I mean, if somebody showed me this, I would just say this person's not going to be happy unless they do a 360 pronto. That's all. Am I done talking? Do you want me to be done talking? I'm not trying to embarrass you. I'm trying to make you think because so far you're underachieving. One thing we should all try to do in our lives, in my view, is try to not underachieve, try to overachieve. Like if the best I could do was salt in the fries at the local fast food restaurant, hopefully someday I'd at least become an assistant manager. And right now, you have a lot more talent than the salt fries in any place or be an assistant manager at a fast food restaurant and you're squandering it. And it's going to get harder, not easier. Are we with one another?
Yes.
Is there anything else you want to tell me? Go ahead.
I feel like I've just been learning like day by day, like even going to the AA meetings, it's been helping me like realize like I don't need the alcohol and then it's just been helping me like I don't want to say progress. Well, they do say in there like go for progression, not perfection. So I do feel like I have been progressing like day by day, taking it step by step. So I don't want to say like I'm a failure, but I do feel like I am.
Well, don't feel like you're a failure. You can't go back and undo anything you've done. You can change how you're acting going forward. So that's a good thing. Right? I think that's a great thing. You seem sincere. I believe you. Let's turn it around, okay? All right? 18 months probation. I can't go along with this 12-month stuff, not with a 3-1. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs. And by the way, I'm going to let you continue your employment at the Night Owl Club. I really think that you should consider other lines of work, to be honest with you.
I mean, I have the only reason why is because I had those warrants that I previously had.
I'm just telling you. When somebody has a 3-1, the last place they should be working in is a bar. I'm not going to stop you from making a living, but I'd suggest you strongly consider getting out of there and getting a regular job that's going to help you build a career. You don't strike me as the type that you were going to Florida A&M. You weren't saying, I'm going to go to Florida A&M and get a bachelor's degree so I could be a part-time bartender. I know you didn't do that, right? Okay, so let's do that. I'll let you continue the employment. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs, and EKG tests. I'm going to make that bi-weekly. I mean, I can't really do much better than that. Bi-weekly for 6 months. If you're clean, then monthly. I still want you on the SoberLink device. Defendant to remain on the SoberLink device. I know it's expensive. I hate to do it, but this is for your protection and the public's. You remain on the SoberLink device until February the 1st of 26, okay? February the 1st of 26. In terms of fines and costs and everything else, 300 fines, 250 costs, 75 victims' rights fee, $50 justice assessment. I want you to go to, well, let me cover this first. I want you to go to AA meetings again at least 3 times a week. I'll cut it down by 1 until you're in intensive outpatient treatment program. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. So 3 times a week until an intensive outpatient treatment, attend intensive outpatient treatment with aftercare, attend the victim's impact panel. The court work program, I hate to make you drive 45 minutes, but I'm not letting somebody just do community service that had this high of a breathalyzer. So I'm going to order 5 days jail credit, 1 serve 4. I'll let you serve 1 of those by way of community service. 1 day, 8 hours community service. You can do that at any nonprofit organization by January the 10th of 26. You're to serve 3 days on the court work program. There's a $35 a day charge for that for a total of $105. Pay fines $300, as I said, cost $250, 75 victims' rights fee, $50 justice assessment. So your fines and costs amount to $675. Screening fee is $60 for $735. Probation fees are $360 for $1,095. You have to pay $2 1/4 for cost of recovery. So your total there amounts to $1,320. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. 14 days to apply for a court-appointed lawyer. I'll be happy to set you up on a payment plan. You can tell me how much you can afford to pay weekly or bi-weekly, whatever the case may be.
Judge, I got a different total.
Okay, thank you. What do you have?
1425.
You know why? I must not have added in the court work program fees. Thank you very much. 1425. Yes, that's exactly what I did. I didn't add those in. So 1425. Wait a minute. 15, 675, 785, 95, 95, 1195, 1220. You know what, Lisa? I think it's 1325. Let's go over these. I got 300 fines, 250 costs, 75 victims' rights fee, $50 justice assessment. So that should be 675. The screening fee, 60 for 735. Probation fees. You're right. You're right. That's 11. You're right. 1425. You tell me how much you can pay bi-weekly or weekly, as the case may be. I'm going to let you pay $65 bi-weekly. How's that? And we'll start that beginning on December the 8th. Is that good? If you don't have the money, you call the court. We'll come in here on or before the due date, 8:30. I'll be glad to give you an extension. I don't care how many times we have to do that. You got a kid, you got Christmas coming up. I believe you're going to do a lot better. I certainly hope so, because I know you've got it in you.
Judge, can I just add one request is can Ms. Thomas come back after 9 months? And if
Yes.
she's compliant?
Yeah, if you've taken care of everything and there's been no violations in the preceding 90 days, then you can come back and petition in 9 months and you'll be discharged. Okay?
Thank you, John.
I wish you well. You're a nice lady. Act like it.
Just kind of confused about
What part?
so you want me to come up here once a week?
No, 3 times. They're gonna schedule you probably on 3 Saturdays or 3 Wednesdays. It depends. I can't in good conscience give somebody who's got a 3-1 the community service. Just can't do it. Okay? But they'll spread them out for you. You go talk to them. If you have a problem, come back and talk to me, okay? Good luck to you. Wish you well.
Thank you, Judge.
Derek Paul Lopez Jr., 25B149536A, B, and C. And then I also have, hang on one second, I have 25B149537. Good morning.
Good morning, Judge. For the record, House Counsel, Attorney Mike Baldwin, B 65417, behalf of my client, Mr. Derek Lopez, sir, can you please state your full legal name? Derek Paul Lopez. Judge, thank you very much. Judge, today is the date and time set for a pretrial and opportunity to work out a resolution. My client will be pleading responsible to careless driving as well as defective equipment, which is tinted windows. As in return, the prosecutor is amenable to dismissing the 2 underlying misdemeanor charges under 36A and B.
Is that what you want to do?
Yes, yeah.
Okay, you got to use your head here, my good man.
Judge, just for the record,
This welcome officer when ordered to stop on 2 occasions. Drove in a careless manner by driving toward oncoming traffic, the flee officer. Now listen.
Judge, I realize he hasn't pled. I've been working diligently with the family. He has a very good support.
Where are they?
And they're in here.
Who's that, your mom?
That's my mom, the one black is my sister.
And we've been working very hard on this particular file because it's important that he understands what the allegations are, the seriousness. And we worked out this global solution where we think that the civil infractions will resolve this. And my client will have learned his lesson.
Well put, Mr. Baldwin.
I try.
Well put. I mean, you got a good deal here. Grow up. How old are you?
Oh, I'm 19.
He's in welding school.
Grow up. Okay? Please. To the charge careless driving, responsible or not responsible. To the charge defective equipment, tinted window, responsible or not responsible. Pleas are accepted. The disobey a police officer and flee and elude is dismissed. 225 on the careless, 120 on the tinted windows, 345. You have all that to pay. $345.
That's up to date, Derek?
Yes, we do.
Judge, he'd like to pay that today and resolve
You
this.
graduated, right?
He's working through his welding school. He did finish high school.
Okay. All right.
He's gainfully employed.
All right.
He's at
All right.
working, so.
Good luck.
Thank you.
No more silly things like that, okay? Best of luck. Thank you.
Thank you, Judge.
Yeah.
Judge, at the police report, I have Jonathan Johnson down in the clerk.
Jonathan Patrick Johnson. You have a question or something, ma'am?
No, we vibe. He's a vibe.
Oh, to me or to him, to the lawyer?
Thank you.
25B148931A and B. I'm sorry, 931, and then I have 25B148932. So
Thank you, Judge. Judge, today is the date and time set for sentencing. We have had an opportunity to review the pre-sentence investigation report. We'd like to announce there are no deletions, corrections, errors, or omissions. Moreover, I spent just a couple minutes with my client, commending him on his election to be admitted into the sobriety court program. He's very excited. We're hoping that the court will allow him today at sentencing to be entered into the sobriety court program. I have nothing else to state. He's ready to go.
Mr. Johnson, your name,
Jonathan Johnson.
what do you have to say?
What's your onset? What is your sobriety date?
I think it's the 18th, if I'm not mistaken.
18th of November?
October.
Okay, gotcha.
I'm just kidding. I knew yesterday was the 18th. I was just teasing. What do you think so far?
Things are going, I guess.
I did not immobilize your vehicle though. How'd that get by me?
I'm like, caretaker.
Yeah, but I gotta immobilize this vehicle. You have a 2013 Chrysler you still own, right? What do you mean, no? Yeah, what do you mean? What do you mean? I don't know what you mean.
That's out of condition.
What do you mean it's out of commission?
It's not working properly.
What does that mean?
Not drivable.
Well, what's wrong with it?
So,
When did that happen?
it's there before, so I've just been trying to,
I got to order a mobilization of it. I have no choice. You had another offense here that preceded this, right?
yeah.
I have no choice but to do that. So I'm going to have to order 90 days of mobilization to be completed within 7 days. That is by November. I'll tell you what, because of the holiday, I'm going to give you, oh, no, I can. I mean, next Wednesday by November 26th. Okay. So Lisa, we're going to have to do that order. I don't, and that's my fault. I wish I had missed that, but I have to order that. I think you've been great so far, Mr. Johnson. You laugh, you smile. That's good. You seem to be doing well. And I really commend you for taking these steps. You're doing the right thing. Is there anything else that you'd like to tell me?
You did have a reason for it. Oh my gosh.
I had a reason what?
Or I guess to use to like use the vehicle or not, but that's all it's about.
Say that again. I'm sorry.
He felt that you actually had understood that there was a reason for his need for the vehicle. What Your Honor is saying is the legislature,
I can't, they make me do things sometimes that we don't want to do necessarily. The good news is you're going to be revoked. The bad news is you're going to be revoked. The good news is, if you haven't been already, the good news is that in 45 days from today, you can come in here and request a restricted license. Now, you're going to have to finish the immobilization period.
Up to both the date was on December 8th.
For who?
That's what I was getting from you all.
December 8th for what? The restricted? I know, but I got to order a mobilization. I don't know why I can't do it. I won't do it in here until you're accepted into the program. It's going to be 45 days from acceptance. You might have started a bond phase. I just had this conversation with one of the probation officers. I'm sorry, I just can't do it. I can't. Okay? This is not my rule. The law, the legislature tells me I have to immobilize. 2 years probation. You cannot leave the state without the consent of the court. You're to comply with all agreements, guidelines, and requirements as indicated in the sobriety court handbook. You're not to violate a law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're to submit to chemical testing on demand of me or the probation officer. Pay all costs associated with the testing, but really, we're going to take care of all that now with our grant. As long as you test every time and you test negative every time, we're paying for your testing. Same thing with the sober link if I order that. Submit the PBTs, ETGs, tests, and chemical testing on demand of probation. Complete 60 days on the sober link. Yeah, I gotta have you do that. That'll be on our dime now. Okay, so you have to be on sober link by end of day. Do you understand that? Do you understand?
Yeah,
You understand what I'm saying to you, sir?
figure it out.
Okay, also you're to attend AA meetings 3 times a week and provide written proof of attendance, obtain an AANA sponsor, attend a substance abuse treatment program, attend the Victims Impact Panel, attend and complete the Armed Specialty Weekend Program. You have to report to sobriety court status review hearings with me every 2 weeks. Again, it's either 7:30 in the morning or 3:30 in the afternoon. Obtain and maintain employment with proof provided. You're doing really well on this. So I'm going to kind of go light a little bit on I think you've given me reason to be optimistic. Fines are 200. Fines are 200. Costs 200. $75 victims' rights fee, $50 justice assessment. So that in and of itself is $5.25. You have a screening fee of 60 for $585. You then have probation fees of $480 for a total of $1,065. And then $360 in sobriety court probation fees. So those are going to bring it, I believe, to $1,425. I'm going to just tell you what, you've been doing well. Complete 6 days jail credit, 1 serve 5. I'm going to let you serve those by way of community service. 5 days community service in lieu of jail, okay? I won't make you do court work program. So that's 40 hours of community service. I'll give you all the way until February 28th to complete that. Community service to be completed by February 28th. Do you understand that? Yes. All right. All right. Do you have any questions?
They're gonna go, these things would be in the probation department.
I'm looking forward to helping you, Mr. Johnson. You have a very nice disposition. Really. Can he pay all this today or does he need time? How much do you have today?
Gotta be $2.
Shirt on the back.
Exactly.
Why are you only earning $200 a week? How are you surviving?
Because child support, stuff like that.
We all paid what?
Definitely. And then I was kind of getting,
How much do you make in your employment though? You don't get to deduct every,
$20 hourly, and every 2 weeks you get paid. So
you're making 1,600 gross if you're working 40 hours, right? Can you pay $60 bi-weekly? Yes. Pay 60 bi-weekly starting December the 8th, but you gotta stick with that. If you don't have the money, you have to come talk to me, okay? You'll meet with probation. I really look forward to getting to know you. Remember, you have to get a SoberLink device by the end of the day. You also have $200 on the PBT file. Just pay this by March the 1st, 26, okay? I'll get, somehow you're gonna have to fit that into your budget, all right? Good luck, Mr. Johnson. Have a good day. Thank you. Keep up the good attitude. I appreciate it. Joseph Raymond Height. 25B1494330 A and B and C. And could I have Mex up here seated at the table? David and Syrian Mex seated at that table. Sir, your name?
Joseph R. Foster. Board of Lake.
Okay. I don't know why he's in front of me. You didn't meet with the prosecutor yet?
No, sir. I did some of the prosecutor. She sent it back out.
That's okay, no worries. I arraigned you already on November 5th on all these, right?
Yes, sir.
The open intax and the no ops, right?
Yes, sir.
My mistake. No worries. And I gave you a personal bond.
Yes, sir.
All right, go ahead and talk to the prosecutor. Did I give you a lawyer? Did you apply for a lawyer?
I was going to get myself a lawyer, but all the plans ended up falling through, and it didn't happen. So I was going to ask if it was okay if I could get a lawyer, sir.
Well, where do you work at?
So right now, I'm unemployed, but I'm working with the temp agency, Express, and
I have to make sure you don't have the money to hire a lawyer.
okay.
Do you have the money to hire a lawyer? I can't just give free lawyers.
Yeah.
You're entitled to a lawyer at the arraignment. After that, it has to be based on indigency. We're already arraigned, right? Did I arraign you?
Yes.
Okay.
So if I could allow the prosecutor, that'd be.
Well, wait a minute, just let's slow down. How much were you earning?
About 800 a week.
Do you have any kids?
No, sir.
Married?
No, sir.
Do you have rent?
No, sir.
Live with your parents?
Yes, sir.
Smart. I'll save you a few bucks. If you want to apply for a court-appointed lawyer, I'll look at it. I'm not making any promises. If you want to waive your right to a lawyer and go talk to the prosecutor, you can do that. It's up to you. If you want to apply, he'll give you a court-appointed petition. I'll look at it now. Okay?
Okay.
And if not, if you decide not to, then you go talk to the prosecutor. All right? Okay, thank you. Tell them if you want a court-appointed petition. Thank you. People against Max. Darian Marquise Mack, 25B1493588 A and B. Your name again? Your name, sir?
Very much.
What's going on, Mr. Max?
I'm not doing.
I'm doing pretty good. You need an additional adjournment, right?
Yes.
Okay.
Sorry.
That's okay. That's fine. We'll adjourn the pretrial for you. What do I have next, Lisa?
2 weeks,
Yeah,
December 3rd at 9:30.
okay.
Sounds good.
December 3rd at 9:30. Any questions?
I know you're on.
You can go down the hall, sir, and get your notice. You're a nice young man, too. Your mother and father taught you well.
Maybe I'll bring you.
Have a good day. Good luck. Jacob Levon Rondo, 24W835234. Is Mr. Rondo here on Zoom, Lisa, or is he? Jacob Rondo here?
No, he's not on Zoom.
Looks like he signed an advice of rights form today. Well, can you call out in the hallway for a Jacob Rondo? And if he's out there, Jacob Rondo, ask him to come in the courtroom, please.
Right now, sir.
Thank you. Priority Waste LLC, 25B14970B and A. All right.
Hi, Judge.
How we doing, Ms. Trombley?
I'm doing well. How are you?
Not too bad. You guys are going to ask for a lot of adjournments on these cases now, right?
Not me, but I am only because this is Alex's file. And
That's all right. Don't worry about it. I'm not going to.
We're trying to keep the files with each other because before we were, you do this one, you do this one. So I'm just trying to keep what he has with him and what are mine with me.
I got it. Does the client stand mute and waive formal reading on this one?
Yes, Your Honor.
I'll enter a not guilty plea. We'll give him a new date.
Okay.
And I'm not even going to bother with a bond, a PR bond, $100. And we're going to set this for 2 weeks from today, which will be December 3rd, Lisa,
Yes, 9:30.
at 9:30. Okay, Ms. Trombley, you enjoy your turkey, eh? If I don't see you.
Thanks, you too. Happy Thanksgiving.
Thanks. Bye now.
Bye.
Rondo's there.
What's that?
Rondo's there.
Mr. Rondo. Where's Mr. Rondo?
Quick to the podium.
Come on up here. Jacob Levon Rondo, 24W835-234. What are you doing out in the hall there, Mr. Rondo?
I have another case I was in.
Oh, you got another one?
Yes.
What are you doing? You want to fill up the coffers here at the 33rd? So you got an impeding traffic. You posted a bond after you didn't show up. Why are you playing games with us? You were supposed to take care of this a year ago.
I'm just busy. It's work.
It is. You're making so much money, you won't have any problem to pay all the money that I'm going to fine you then. If you're so busy working that you can't come to court, you must be loaded. What's that?
It slipped my mind.
Slipped my mind. You know the title of my book? Don't tell the judge I forgot, right? I'm just telling you. What other excuse you want to move on to?
No, that's,
Do you want me just to post, you want to just apply the bonds?
yes.
Let me just double check that it's in your name here. I don't see the receipt right now. Did-
Oh,
His name.
It's in his name?
Yep, 237 cash.
Where do you work at?
I'm right now working for MLS Construction and Method Innovation, but I'm boss.
Why didn't you show up here for all this time? I'm serious. You got to use your brain, son. I'll reduce your fines for you, okay? Reduce fines to $195. So we'll send you some money back. You go down, and sign the bond over, and they're going to refund $42 to you, okay? I probably shouldn't have done that. Don't tell anybody. Good luck. Stay out of here now. I don't want to see you again, okay? Shakira Nicole Lindsay, 25B1495778 and B. Good morning.
Good morning, I'm pleased to sound before Joseph Humphrey on behalf of Ms. Lindsay, Chief of Pros and Podium at this meeting.
Good morning to you, Mr. Humphrey. Ma'am, your name? For purposes of arraignment, does she stand mute, waive formal reading?
Yes, Your Honor.
So what do we got? A super drunk, we got an expired license, and then we have, that's it, right? Is that it?
Yes, Your Honor.
2 charges. And what's the prosecutor going to do? They're going to offer impaired and distracted driving. But first of all, she stands mute on all of these charges, right?
That's correct, Your Honor.
So she's going to plead to the distracted on the drive-while license expired. And that drive-while license expired will be dismissed, and she's going to plead to operating while impaired with the super drunk to be dismissed. True?
That's correct, Your Honor.
Is that what you want to do, ma'am?
Yes, sir.
How high was the breathalyzer or blood result?
It was 2.4, I believe. 0.24.
I get it, but it's quite high. Right?
Yeah.
All right, if you plead to impaired driving, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs of all those 4 points. License suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. That is the possible penalties on the impaired charge. I'll then dismiss. Once you plead to that charge and you plead to distracted driving, which is a civil infraction, I'm going to dismiss the super drunk, which is punishable by up to 6 months. Your lawyer did a good job on that. And the expired license, which is a 90-day misdemeanor. Do you understand that? You agree to that? And did you sign, read, and understand the advice and rights? If you plead guilty, you will be giving up all those rights, and we are not going to have a trial of any kind. You understand that?
Yes.
Any questions before we go on? To the charge operating while visibly impaired, how do you wish to plead? On October 26th, it looks like, 2025 at 9:05 PM, were you operating a motor vehicle on Dixner I-75 in Brownstown Township?
Yes.
Prior to operating that motor vehicle, did you consume alcohol? And if so, what did you drink and how much?
Yes, 3 cocktails and some,
What kind of cocktails?
it looks like mixed drinks like slushy from crab and karaoke,
How many drinks did you have?
3 of those.
And what else?
And then after I left, I had probably like some shots.
What do you mean probably like? Do you remember?
I don't remember how many.
This was only October 26th. It was
Yes.
3 weeks ago.
Not,
How many other drinks did you have and what were they?
I had like some, like probably like 4 shots and some
Of what?
tequila,
What else?
2 cocktails and
What kind of cocktails?
lemon drops.
This is on top of the slushy drinks you were talking about
Yes,
before?
And I
Okay.
hadn't eat anything.
Okay, what else did you drink?
That's it.
And was your ability to operate the motor vehicle impaired because of that alcohol consumption?
Yes.
Why were you pulled over by the police?
He said because I was driving too slow.
How fast were you going?
35,
In a,
50, I was lost.
so he pulls you over. He administers a breath test, a PBT, right? And then you're transported to the police station. Is that what happened after you were arrested?
Yes, sir.
And did you take the intoxilizer, the breath test?
Yes.
And counsel, you stipulate that the results were 0.24 for purposes of the plea?
Yes, Your Honor.
Are you on probation or parole?
No.
Ever had another one of these?
No.
To the charge distracted driving, how do you plead?
Yes.
Responsible?
Yes.
I'll accept your plea to operating while impaired. I'll accept your plea to the civil infraction charge of distracted driving, dismiss the super drunk, dismiss the drive while license expired, refer you for a screening and assessment. That's pretty high though, young lady. Where does your client work at?
She's a stay-at-home mom. Yeah, she had a child with special needs that she cared for, and she educates that child, and she has another child that's well in high school that she also cares for as well too. And she is very remorseful, Yana. She does understand that this was a great mistake on her part, and I don't believe that the court will have to see her again after this.
All right, I got it. No alcohol. So I'm going to give you $1,000 personal bond. You don't have to post any money. But I do want you going to AANA in person at least 2 times a week, okay? You have to go in person. We're going to hand you a form. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. AANA twice a week. You cannot leave the state without consent or violate a law. And you must appear in court as directed. Do you understand all that, ma'am?
Yes, sir.
Mr. Humphrey, anything else?
I believe that is complete, Your Honor.
We're gonna-
Yeah, I'm sentencing date.
Yeah, we're gonna give you the sentencing date right now. And then you just double check your calendar. What do you have for me, Lisa?
December 3rd at 8:30.
Is that good?
Just get my phone.
Take your time.
Yeah, that's fine. We can make it.
Okay, December 3rd at 8:30. So you've handed her a form, John?
Yeah.
Okay, ma'am, go down the hall, get your notice, and then go across the hall to probation, where you're gonna fill out a questionnaire and be interviewed. I have to order that, a screening and assessment. So you'll fill out a questionnaire, you'll be interviewed by probation, and then you'll come back for sentencing on that date that I gave you, December 3rd, with your lawyer. You'll have a chance to review the report and recommendation with your lawyer, and we'll go from there, okay? All right? You're welcome. Well, you're smiling. That's good. Good luck to you, Nora.
Thank you, I appreciate it.
Thank you, Your Honor.
Thank you. Nice to have you here.
Yeah, nice to see you again.
It's been a while, hasn't it?
Yes, sir.
All right, take care. All right, people against Roden. Anthony Lee Roden Jr. I'm gonna appoint you a lawyer. You go out and give you a lawyer. Want to give him a lawyer.
Yeah.
258-149-141. How you doing there, young man? Your name? You should have been a lawyer. Look at you. You got this pled to distracted driving, right? To the charge distracted driving. How do you plead? Responsible or not responsible?
Responsible.
What do you do for a living?
I'm a supervisor at UP Rudolph in restaurant.
Good. All right. 175 and you're all set. Please accept it. Original charge dismissed. Good luck to you.
Thank you so much.
Have a good day. John Gregory Smallwood, 25B, 149, 428. Good morning, Mr. Smallwood. Your name?
Not small?
All right. Did I, you're gonna hire a lawyer?
Yes,
Okay, you can afford your own?
yes.
I'm just requesting adjournment to after.
No problem. So I guess we're gonna do December 3rd again, Lisa?
Yes, 9:45.
Okay, at 9:45. Fair enough?
That's very.
Okay. Any questions?
No, sir, thank you.
All right, you can go right down the hall and we'll give you a paper notice, okay?
Appreciate it.
Best of luck. Thank you. Mr. McCure, you don't have anything in here, do you?
Oh, sure. I just wanted to see you.
Nice.
Saw you on a YouTube
Uh-oh.
a couple of weeks ago,
Uh-oh.
rattling on the chair there and waving your arms, and I just wanted to see how our friend did with his garbage.
Yeah. It's tough. How you then? Life's treating you good? Go off the record, please. And off of YouTube too, if we can right now. How are you? Good?
Good.
Things in Rockwood good?
Yeah, everything seems to be okay.
Good. You're not doing anything. You're completely retired from everything. Then.
Well, I retired from my insurance agency
Right.
10 years ago, but I do some security work for the Gilbert family.
I remember you told me that last time we talked.
Yeah.
That's great.
Yeah, I've got a big deal coming up Saturday, so it's
Nice.
Mr. Gilbert is a pretty cool guy.
How is he kind of getting back to normal?
He's if he has to go a long distance, he's in a wheelchair. But once he gets to, like the grand opening of Hudson's a couple weeks ago, he was in a wheelchair coming from the parking lot upstairs, and then he did speak to the crowd. There were 800 of his closest friends there for the opening of Hudson's.
Nice.
But
Where are these years going now?
I know it. You know, I one of my kids is retired already, and we also have our first great grandchild.
Congratulations.
Yeah,
Boy or girl?
little girl.
Fantastic. I got 5 grandkids now.
This is a great though.
I know. I get it.
Yeah.
I get it.
Oh, it's fun.
Well, that's
You know,
fantastic.
what's so much enjoyable is to watch our son and his wife be grandparents.
Sure.
That's pretty cool.
I believe it.
Yeah.
I believe that. That's great.
Hey, this is pretty nice. I read this. This is pretty cool.
Yeah.
Yeah.
I'm proud of him. He's really turned out to be a real good lawyer. I'm really proud of him.
Good.
I don't tell him that, but he's doing really well.
Right.
Working with a real good firm. So, yeah.
So it's, no, I just wanted to come in and see what was going on with, it popped up on my computer. I don't know how your show, did you have YouTube earlier? It must have been a YouTube thing.
I put these on YouTube. A buddy of mine harangues me if I don't. He lives in Florida and he's, why aren't you on YouTube? Why aren't you on YouTube? If somebody forgets to turn it on or whatever. Oh my God.
I when you said Wednesday the 19th, I went on to put that on my calendar right away so I could.
Oh, Mr. Boyd,
Yeah.
it's tough.
Oh my goodness.
It's tough. I can't really talk about
I
it.
know.
But it's tough.
I was feeling for you today. You should do that one at 4 o'clock in the afternoon, not to ruin your whole day.
Yeah,
You know.
I know.
Yeah, that's tough. But yeah, that's so I saw that and I said, well, I gotta come in and say, thank you for acknowledging me and remembering.
Of course I remember. You never changed. You look the same as you did 30 years ago.
Yeah, it's been
You're
a
good.
minute.
Sit down, man. You're
Yeah,
good.
it's been a minute.
Nice to see you.
Yeah. It's great to see you.
You do look great.
Well,
Are you leaving? 70?
76.
Yeah, you look great.
But, you know, the firefighting foam got me.
The what?
Firefighting foam. I have multiple myeloma now.
Wait, well, go, yeah.
Yeah, I was a volunteer fireman for 45 years.
If you see me
And right next to my locker,
typing
4
4-3 bond condition,
55-gallon barrels of that foam.
I just got into this habit for a while because
Well,
it's the same.
I'm going after it. So
Can't leave your state,
I have it.
can't violate any law or ordinance, and you have to
But I
report
feel
it
good.
to that still.
Really good to see
So-
you.
Really good. Thank you.
First, always. Thanks a lot. You too, Tom.
Enjoy the day. My wife says, go have fun. So I enjoyed this.
Take care. See ya.
See you.
Do you by chance have a key to the bathroom door?
I do.
I don't have one yet. And I better go now, I don't leave.
Is there a code that I?
National Habitat. Good morning, this is the public defender, the librarian, the public defender. Likewise, does not believe a topic exists, but if one does, we also.
All right. And the court for its part also does not believe there's a conflict either under Michigan court rules or the cases decided there. To the extent a conflict may exist, given the waivers, the court will consent to hear the matters. Court does call the case of People versus Gary Hall.
I just felt this for the people. And these are both arrangements.
They're both arraignments. All right, Mr. Hall, can you state your name, please?
Gary Hall.
All right. Mr. Hall, there are two cases that I need to arraign you on with 3 different charges. All right, sir?
Okay.
Yeah. Starting in case 123-1380. Sir, that is a complaint that alleges that on or about December 11, 2022, location of I-94 near State Street, Pittsfield Township, Washtenaw County, State of Michigan. Count 1 alleges that you did operate a motor vehicle while intoxicated. Do you understand the nature of that charge, sir?
Yes, I do.
That's a misdemeanor punishable by up to 93 days of jail, a $500 fine plus court costs, community service, and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand that?
Yes.
On that complaint, count 2 alleges that you did operate a motor vehicle while you're at the same date, same time, and same location, that you did operate that motor vehicle while your driver's license was suspended, denied, and or revoked. Do you understand the nature of that charge?
Yes, I do.
That's a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs, and your vehicle is subject to immobilization. You understand that, sir?
Yes, I do.
All right. In the other case, 123-1472, that is a complaint that alleges that on or about March 30th, 2023, location of US 23 near Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan. Count 1, well, the single count on that complaint alleges that you did operate a motor vehicle while intoxicated and lists this as a second offense. You understand the nature of that charge?
Yes, I do, sir.
That makes it a misdemeanor punishable by up to 1 year in jail, a $200 to $1,000 fine plus court costs, community service, any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of the emergency governmental services. You understand all of that, sir?
Yes, I do, sir.
All right. First question I have for you is, do you wish to be represented by an attorney on these cases?
Yes, Your Honor.
Yes?
Yes.
All right. So public defender cases.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Hall, we would waive any further reading. My client would stay in mute as to all charges in both cases. I would ask for an adjourned pretrial date. And then also if Mr. Hall knows what his expected out date may be, if he maybe could comment on that.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea in both cases. Mr. Hall?
Yes.
Do you know when you're going to get out of jail there?
It's the 27th on Thanksgiving.
You'll get out on the 27th?
Yes.
What kind of charge are you being held on?
It's a stalking charge. It's a misdemeanor. I got 90 days and 22 months probation. And a few other things too. I think I got to wear a GPS tether when I get out too for about 45 days.
Okay. So the 27th is when you're out?
Yes.
All right. I will adjourn this. When is my first date? December. I'll adjourn these matters to December 3rd, 2025, 9 a.m. or as your invite indicates. All right, sir?
Okay, so do I get out on the 27th? Or am I on a
Well,
hold here?
that's up. That sentence was imposed by Clare County, correct? Is that correct, sir?
Yes.
Okay, I don't have anything to do with whether or not you get out on the 27th.
Oh, that's my out date. I was just asking if I'm gonna be on a hold, because they're supposed to call Ann Arbor to see if I'm able to get out or not because of the misdemeanors.
Well, do you think if I set it for the 3rd, you're gonna be able to get down here? Because otherwise I'll put a hold on you and we'll come get you.
Well, I can be on Zoom. I can get on Zoom now. I couldn't get on Zoom before because I just moved out to Clare County. I didn't have Zoom because I didn't have Wi-Fi. And I got
Your Honor, if I
Wi-Fi
may-
now. I can get on Zoom, talk to you.
Mr. Hall, yeah, Your Honor, I think he's just asking if he was receiving PR bonds in this case, which would be my.
Well, I know what he's asking, but I mean,
But I mean, if
Here's
you
what
wait
I'll
out in
do.
the courtroom, I'm sure I can get my dad to bring me down there, to the courtroom on the 3rd.
I'll adjourn this matter to December 3rd, 2025 at 9 a.m.
Okay.
I'll set his bond in each of these cases in the amount $10,000. Do you have the alleged BAC on these matters?
Yes, Your Honor. So one was 0.15/0.14. It's an older case. So it was not the intoxilizer, it was the data master. That one was a stop for speeding. The other is a 0.116 single vehicle crash.
And they were, okay, and they were.
And then priors from 2016.
Got it. Okay, so on the case ending in 1308, I'll set his bond in the amount of $15,000 personal recognizance, standard conditions, including no assaultive behavior or any possession of any weapons. There is also to be no use of any alcohol, recreational marijuana, or any illegal drug. I will indicate that you are to report to community corrections for placement on a scram tether unit on these matters. And then this one is adjourned out. On the other case ending in 1472, I will set his bond at a $25,000 personal recognizance bond. Standard conditions, including no assaultive behavior or possession of any weapons. No use of any alcohol, recreational marijuana, or any illegal drug. I will also sign a community corrections order placing you on the scram tether unit. You are to present yourself, which is you're going to have to get yourself down here because you're going to have to present yourself to community corrections for that tether. You're really to do that within 24 hours of your release. Understood?
So you say I have to bond out within 24 hours? Or, when I get released, you're saying when I get released?
When you get released, you've got personal recognizance on these cases. When you get released, you need to get yourself down to community corrections because from the time that you're released, you need to report within 24 hours.
Okay, so if I can't get a PR bond, can I get out on the 27th so I can do that?
Mr. Hall, you have.
I just gave you 2 PR bonds.
Okay.
Okay?
All right.
These cases will not be holding you.
Okay. That's all I know.
When you get out, you have to get down here to community corrections so that you can be placed on the scram tether unit.
I hear you. Okay. So as soon as I get out, do this. Okay. Now I'm on probation here too when I do get released. So how is that going to work, Your Honor?
Mr. Hall, when you get released, call the public defender's office, okay? Because I also believe you'll be released on a holiday and community corrections may be closed. So I need to further instruct you, okay? So definitely call the Washtenaw County Public Defender's Office, all right?
On the 27th? Or on Monday?
Call me tomorrow. You can call me tomorrow would be great, or when you're released. But if you do not call me, still go to community corrections with the first business day after you're released.
To do this.
Okay, I'll give you a call.
Thank you, Mr. Hall.
Are you gonna be able to do all of this, Mr. Hall?
What was that, Your Honor? I couldn't hear you.
Are you gonna be able to get all this done?
Can you repeat that, sir? I didn't hear you. Sir?
Are you going to be able to do what I told you to do?
Yes, sir, I will. I promise you.
Because if you don't, I'm just gonna change your bond and we'll bring you down.
I promise you I'm gonna do what you told me to do, sir. I promise. I promise.
Your Honor, not to complicate things, I do have a question. Is community corrections open the day after Thanksgiving?
I have no idea. I don't think they are.
Okay, so yeah, Mr. Hall, call me as soon as you can at jail, all right?
All right, I promise I will. Thank you.
Thank you, Mr. Hall. Appreciate it. Thank you, Your Honor.
You know what I'm gonna do, because that's Thanksgiving holiday and it may not be open. I'm gonna also order that when you report to community corrections, they're to give you an EBT test, because I want to see if you've been drinking.
Okay.
All right, thank you.
Thank you, Mr. Hall. We'll be in touch. Call me.
Thank you. I will.
All right, take care.
You too, sir.
Okay, that was almost a full day's work. I'm gonna leave now. That is. Yeah, that's gonna be some work. Court calls the case, People versus Michael DeWitt.
Morning, Your Honor. Dan Garrett on behalf of Mr. DeWitt. Step forward. You state your name, Michael. State your name.
Oh, Michael DeWitt.
Good morning. Your Honor, at this time, I'm asking for a final settlement conference.
Jury final settlement conference will be set for December 5th, 2025, 9 a.m. Jury selection, December 8th, 2025 at 8:30. Both of those proceedings are in person and bond will continue.
Your Honor, with respect to bond, it doesn't make much.
Really?
Yeah, I knew it. I knew I had to follow that other date. He has some travel in January. It may not matter. We can address it the next time, but can the court amend bond now, or should he just want to make?
Depends on where he's going.
Yeah, tell him, Michael.
Phoenix for my nephew's wedding.
You like your nephew?
I do.
Okay, all right. Well, I decided to ask. What date?
So it's January 6th is his flight, and then you return the 29th to Detroit. Is that correct?
Yeah. So the reason it's so long is that my parents are in their 80s, and so I'll be spending some time.
Got it. Understood. All right. So January 6th, and so those are the dates. Those include the dates of your travel.
Yes,
correct. January 6th through to January 29, 2026.
Correct.
Defendant may travel to Arizona. All right, got it.
Thank you, Your Honor.
Thank you. That's called the case of the People versus BJ. Is it Pudell?
It is, Your Honor. Morning, Your Honor. Dan Garrett on behalf of Mr. Pudell, and I believe both matters now.
Vice podium.
I think, is he on board?
He is in 1789, isn't it right?
Oh, okay.
We filed an appearance on that matter, Your Honor, as well. So I don't know.
Gotcha. Okay, well, let's deal with the arraignment on that. You waive reading on that.
We do, Your Honor. Stand mute, please.
Defendant every way for reading, standing mute, court will enter a not guilty plea on that case. All right. So what are we doing?
Ask for both matters to be set for a settlement conference, Your Honor.
This one, did this come down?
Yeah, one was a remand.
Got it. All right. Jury final settlement conference in both of these cases will be set December 5th, 2025, 9 a.m. Jury selection, if necessary, on both matters will be set December 8th, 2025, 30. Both of those proceedings are in person. With respect to bond on the 1789 case, You have any issues?
He already has the stay away from the complainant in the one matter. It's the same stay away. So
It's the same person.
it's my understanding, his sister, yes, Your Honor.
Okay, so I'll set his bond at $25,000 personal recognizance bond, standard conditions, including no assault behavior or possession of any weapons. There'll be no alcohol, recreational marijuana, or any illegal drug use. I will indicate that he is not to have contact with Nisha Shamana.
Oh, no. It's, yeah.
Okay.
Right. Great, thank you.
Thank you very much, Your Honor.
Thank you, Your Honor.
Court calls case People versus Benjamin Kritzer.
National Feltus for the people.
Good morning, Your Honor. Our defendant, Mr. Kritzer, is approaching as we speak. Mr. Kritzer, can you state your name for the court, please?
Good morning, Your Honor. Benjamin Kritzer.
Good morning.
Thank you, Your Honor. We are working towards resolving this issue, but we've discussed with Madam Prosecutor, final pretrial conference on December 5th. That works for the court.
Jury final settlement conference, January 5th, 2020. Yes, sir. I meant December 5th.
Thank you, Your Honor.
Thank you.
Thank you very much.
Well, hang on.
Oh, sure.
Now that I've got the right month.
Yes.
December 5th, 2025, 9 a.m. Jury selection, if necessary, will be December 8th, 2025 at 8:30. Those are both in-person proceedings.
Thank you, Your Honor.
All right.
Understood.
Thank you.
Good day.
Bond continue. Court calls case People versus, is it Shikdal Singh?
National Feltus for the people.
Good morning, Your Honor.
Morning, Mr. Wagner.
Joseph Wagner on behalf of approaching. Your Honor, we've had an opportunity. Shukdal Singh.
All right, go ahead.
Good morning, Your Honor. We've had an opportunity to have a pre-conference with the prosecutor. We've executed forms that are in front of Your Honor. We understand that no contest pleas aren't taken at this time, so we're willing to come back at whatever time.
Okay, I have no forms, and that's probably because you were trying to do a no contest plea, so they weren't going to get to me. Yeah, but they weren't going to get to me because I can't do it today.
It's not that the court's holding them, just not in the file.
Yes.
Thank you. We're just looking for another date, Your Honor.
That's correct. As soon as possible, Your Honor.
That would be my December 3rd, 2025, 9 a.m.
It's agreeable. I'll ask Bond to continue.
Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Brandon Nash.
National Feltus for the people.
Good morning, Your Honor.
Oh, boy. Oh, no. Again?
Good to see you. How are you?
I know. Why? They're like everywhere. All right, go ahead.
Hi, my name is Sam Fisk. I'm a student attorney with the Civil Criminal Litigation Clinic at the University of Michigan Law School. I'm seeking permission to practice under MCR 8.120 to represent defendant Brandon Nash under the supervision of Sarah Sallin.
Good morning, Miss Allen.
Good morning, Judge.
All right. Permission to practice is granted, I guess.
Thank you.
No, that was enthusiasm I had. Go ahead. All right.
So
what are we doing?
Similar to the last case, we've agreed to a no contest plea for retail fraud in the third degree. We weren't able to submit that paperwork before yesterday, so we're seeking to have the next possible date to enter that plea formally.
December 3rd, will that work? 2025?
Yes, Your Honor.
Because you guys don't have finals, right? I'm kidding. I'm kidding. That was, I just didn't think they had those. I didn't know. All right. December 3rd, 9 a.m. Bond will continue. Is he here?
He's on.
Yeah, he's on Zoom.
Mr. Nash, can you state your name? He just didn't state it.
Brandon Nash.
All right, thank you. Bond will continue. Thank you, folks.
Thank you, Your Honor.
See you then.
Court calls the case, People versus George Walker.
George Walker. And good morning, Your Honor. Robert Ellman with it on behalf of Mr. Walker.
Okay, what are we doing?
Your Honor, I believe we're trying to reach a resolution in this matter. There's an issue of restitution that we're trying to resolve. So at this time, I'd be asking for an adjournment.
That's correct, Your Honor.
All right, are you going to be able to get that resolved by the 3rd, or you need more time?
I think the 3rd is realistic. We've had good contact with the victim. We're just trying to figure out some of the details.
Got it. I'll adjourn this matter December 3rd, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Elizabeth Raggett.
That's the focus for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Raggett.
Hi, I'm Elizabeth Raggett.
All right. What are we doing?
Your Honor, we're asking for some more time to speak with the prosecution about a resolution.
December 3rd be enough time for?
I'll do my best, Your Honor. Yes.
Thank you, Your Honor.
Adjourn the matter December 3rd, 2025, 9 a.m. Bond will continue.
Okay.
Court calls case of the People versus Brandon Bovee.
That's the focus for the people.
Good morning, Your Honor. David Chan, on behalf of Brandon Bovee, is approaching. Brandon, can you please state your name for the record? Good morning, Your Honor. Brandon Bovee.
Thank you.
We are going to set this for a final settlement conference. If that December 5th date is still available.
He always asks for his own date. I should just give him another one. This is Shan.
I'm trying to help you organize your docket, Your Honor.
Yeah, no, I got Ann. I'm good, okay?
This is the thanks that I get. Geez.
Jury final settlement conference, December 5th, 2025 at 9 a.m. Jury selection, if necessary, December 8th, 2025 at 8:30. Both of those proceedings are in person and bond will continue.
Thank you, Your Honor.
Thank you. Thank you. Court calls case of the People versus Reginald Sims.
That's the focus for the people.
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Sims, who is present and consents to appear via Zoom. Mr. Sims, can you state your full name?
Yes, Reginald Sims. Good morning.
Good morning.
Your Honor, date and time set for a pre-trial. You should have an executed plea form.
I have a plea form that indicates that the defendant will be pleading to an added count 2 of operating while impaired first. The 93-day offense upon the successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's an accurate recitation of the agreement, Your Honor.
Good. All right, Mr. Sims?
Yes.
Can you raise your right hand, please, sir?
Yes.
Do you solemnly swear or affirm that testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again, please, sir, for the record.
Reginald Sims.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. The court could also order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of right form, is that correct?
Yes.
Is that correct, Mr. Sims?
Yes.
You have any questions regarding any of those rights?
No.
I'd ask you if you've got a copy in front of you, look at paragraph 5. Those are your trial rights. You understand that you're giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
December 24th, 2024, at the location of Merritt and Munger Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
Do you know what you had? And how much?
Yes, Your Honor.
Okay, what'd you have and how much?
I had one social cocktail with my daughters. I'm not a drinker, so it was Christmas Eve, and I had a social drink, and it didn't work for me. I'm a non-drinker prior to the incident, but I was caught up.
So you had one drink?
Mr. Sims, just tell them what you had to drink.
A martini, lemon drop of some sort. Holiday.
All right.
It was a holiday
So
spirit.
yes, I get you. And so there was a crash of the vehicle, is that correct?
Yes.
What happened?
I wrecked my vehicle 2 doors from my home on Merritt Road.
Okay, so you're driving along. What happened that caused the accident?
Your Honor, I remember coming out of my driveway, and like I said, it occurred 2 doors from my home. I don't remember. It's been a year now. After the incident, I was kind of fresh on it. 5 or 6 months.
Did you hit another car? Did you hit a mailbox? What happened?
A tree.
You
my
hit a
car
tree?
Yes.
Okay, so you drove into a tree. Is that correct?
Yeah, I kind of hit a little bit of the dip. It's what do you call it? We had the dips in the road there. So my back rear tire, I believe, caught the dip in the road there, and then it spun me around to the tree. The valleys, the water.
Okay, so after did the police arrive?
Yes.
Were you ultimately arrested?
I was taken down to the hospital.
Right, but you weren't free to go at the time, so you were arrested, correct?
I believe that's how it went, Your Honor. I was not aware of that thereafter. So, yes, let's say yes.
Okay, did the police take you to the hospital?
Yes.
In the back of their car?
I don't recall, Your Honor. I don't believe so. I believe I was taken in an ambulance.
In the ambulance.
It was in an ambulance? Okay. And was there a blood draw at the hospital?
Yes.
All right. And were the results of that blood draw a 0.103?
I believe that's what it was, Your Honor. Now being
okay, you're not disputing those results, are you?
We'll stipulate for purposes of the plea, Your Honor.
All right. And so you have no reason to dispute those test results. Is that correct?
Correct.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
I'm sorry, can you repeat your question, Your Honor?
Okay. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
Sir, I do have to advise you, if you commit misconduct between the time that I accept your plea and the time of your sentencing, that you would not be entitled to any sentence evaluation or recommendation, and the court would not be bound by that, nor would you be able to withdraw your plea. You understand all of that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
You are satisfied?
Yes, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be December 22nd, 2025, 9 a.m. Bond will continue. Do I have probation in Texas?
Yes.
I do. All right. Mr. Sims?
Yes.
Need you to hang on the line. We're going to put you into a breakout room with my probation department so we can get the process started, okay?
Very well.
All right.
Your Honor, that was 10 a.m.?
9 a.m.
Thank you.
9 a.m. All right.
Thank you, Your Honor.
Thank you. Did I say 10? Oh, okay. I'm just saying, well, after the whole January thing, I'm just a little nervous.
Anything else?
All right, that's right. Court does call the case, People versus Sharon Abbott.
Actually, felt for the people.
Carolyn Fox.
Understanding Mr. Howard's going to be entering a plea of guilty to 1 count on unauthorized use of a motor vehicle. Is that accurately stated?
Yes, Your Honor.
Mr. Howard, how old are you?
43 years old.
How far did you go in school?
I had about 3 years of college.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation. I'm going to set this for sentencing. That's going to take place in about 4 to 6 weeks. At that time, I intend to place you into my community control program and look to transfer this case back up wherever Fayette County is and let them deal with this. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
Yes, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page there's a signature above the line defendant. Is that your signature?
Yes, Your Honor.
Did you review this with Mr. Moss before you signed it?
I did, Your Honor.
Are you satisfied with the representation that you've received in the case?
Very satisfied.
You're going to enter a plea of guilty to 1 count of unauthorized use of a motor vehicle. It's a 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. Also carries with it an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, as to count 2, that on or about September 9th of 2025, City 11 in Warren County, Ohio, defendant Christopher Howard was operating a vehicle which had been reported stolen. A defendant had rented the vehicle through Avis. It was due back on July 29th of 2025. Avis had exhausted all available options to recover the vehicle.
Anything on those facts, Mr. Moss?
No, Your Honor.
Mr. Howard, did you hear those facts?
Yes, sir.
Do you admit they are true?
They're true.
Do you understand the rights you're giving up by entering a plea?
I am.
What's your plea?
I'm going to plead guilty, sir.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to go into the matter of the sentence today. I'm going to do a pre-sentence investigation. We'll see you back here in about 4 to 6 weeks.
Your Honor, he is asking to be heard on release. He's asking that he get an OR bond so that he could go to Fayette.
Here's the thing, Mr. Howard, if I send you back to Fayette County, because if I release you, they have a holder from Fayette.
Correct.
And I don't know what they're going to do with the case, so I don't want to be in a position where you're bouncing back and forth, so I'm not going to release you until the case is over.
I respect that, Your Honor.
Yeah.
Okay.
All right.
Fair enough.
All right, that's all.
Thank you.
Next is the case of the back, case number 25 CR 43014. Can you need a minute, Mr. Moss, or are we good?
No, we're good.
All right, present before the court is Mr. Back, represented by Mr. Moss, and we have Ms. Nicholson from the prosecutor's office. We are here today for a conference, actually a pretrial, and we are setting this for trial, right, Mr. Moss?
Yes.
All right, so Mr. Back, in the state of Ohio, we divide the responsibility at a trial between the judge and the jury. The judge decides what the law is and the jury decides what the facts are. So if you were to try this case to a jury, I would instruct the jury on what the law is. All 12 of them have to be convinced beyond a reasonable doubt that you did this in order to find you guilty. They also have to agree that you're not guilty. If they can't agree, then that's a hung jury in that particular case. If you waive your right to a jury, I will decide both what the law is and what the facts are. I'm not going to find you guilty unless I'm convinced beyond a reasonable doubt that you did this. And you keep all of the other rights that you have, the right to testify if you want, the right to remain silent, the right to confront witnesses, compel witnesses. All of those rights remain the same, except I decide whether or not you're guilty. Do you understand all of this?
Yes, Your Honor.
Have you had the opportunity to talk with your lawyer about it?
We briefly talked. He's going to talk more about it. On this, he discussed where, I won't need the 12 juries. I think I'll trust your judgment on this case.
Okay.
Is that,
Are you satisfied with the representation that you've received from Mr. Moss so far?
yes, I am.
All right, is this what you want to do?
Yes, Your
All right,
Honor.
there is a one-page document in front of you called jury waiver.
Okay.
If this is what you want to do, go ahead and read that over and sign it.
Okay.
I am going to accept the jury waiver. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you have been fully advised of your constitutional rights in that regard. Anything else for today?
I was going to ask if I can be released off the ankle monitor.
Ms. Nicholson?
We would object. He's only been on it for a little over a month. I know that when there was the original issue of the bond revocation, because he had tested positive after arraignment, and the victim has not been made aware of that request, and I know that she would adamantly oppose it. And I know she would have been here to address that if she knew that was going to be raised today, but we were under the understanding the defendant's presence had been waived, which is why I believe she did not appear. She has appeared at all the other hearings.
Why don't we do this? Why don't you go ahead and get the position of the victim on that? I'll take the matter under advisement, and you can let me know what the position of the victim is.
Okay.
Anything else, Mr. Moss, on that issue?
Well, Your Honor, just that he's been consistently coming to court. He's even here today, even though he wasn't required to be. He's maintained work and been fully compliant. So I think that he's a good candidate to have it removed. He'll be in court on Tuesday on her trial, the victim's trial, the alleged victim. So I think it's time to take the monitor off, but I'll leave it to the court's discretion after hearing from the victim.
Yeah, I'll take a look at it.
Okay.
Okay? All right, we'll go ahead and get it set for half day.
Yeah, that should be sufficient. I mean, I don't know how much evidence the defense plans to present, but I would imagine I have the victim and a couple law enforcement officers.
All right, let's set it for one day.
Okay.
Okay? Let's set it for a full day. Okay? All right, that's all.
Officer Tucker on behalf of Sharon Abbott. Sharon Abbott.
Good morning.
And Your Honor, we're requesting an adjournment. I have been speaking with Ms. Feltes about a potential resolution, and we just need some more time. If we could go past the 3rd, that would be appreciated.
Can I do it for her? Sure. You think so? I don't know. 17th. Will the 17th work for you?
Thank you.
Yes, Your Honor.
Adjourn the matter December 17th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right, thank you. Bond.
Thank you, Your Honor.
Yes, bond. Court does call the case of Tatiana Tedder.
Ask both of some people.
Sherilyn Foster Tucker on behalf of Tatiana Tedder, who I believe is on the Zoom.
Yes, I'm on here.
All right, state your name.
My name is Tatiana Tedder.
Thank you.
And we're also requesting an adjournment to try and resolve the case.
You want the same day?
The 3rd is fine for this one.
Wow. So nice. December 3rd, 2025, 9 a.m. Bond will continue. All right.
Thank you, Your Honor.
Thank you, Ms. Tedder. Court does call the case of People versus Billy Lee Pauley Jr.
Ask both people.
Kyle Bedell on behalf of, but not with, Mr. Pauley.
Good morning, Judge.
Your Honor, today's the date and time set for pretrial. I've had no contact to date with Mr. Pauley. There was some sort of clerical error that got it set on the docket today. I have no explanation for Mr. Pauley's.
That what?
Pardon?
There was some clerical error.
That ended up being set on the docket today. I was something about me being, the PD was previously appointed and then I was reappointed. But either way, we're here, I'm here, and Mr. Pauley is not.
Times 93 days jail. Court costs are all those 2 points. Do you understand that, sir?
Yes.
You're also charged with distracted driving. That's a 0.7 infraction. Do you understand that?
Yes, sir.
All right. Did you sign, read, and understand the advice of rights form here today?
Yes, I
If
did.
you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, I do.
To the charge distracted driving, you plead responsible or not responsible.
Responsible.
To the charge driving on a suspended, how do you plead? Guilty or not guilty?
Guilty.
Were you operating a motor vehicle October 13 at 25 at 6:02 p.m. on Western Telegraph in Brownstown? Was your license suspended, revoked, or denied?
Yes, sir.
Which?
Suspended.
Why?
Revoked, Judge.
Because of drunk drivings?
Yes.
Are you on probation or parole right now?
No, sir. In 2008.
Anybody forced you to plead guilty?
No, sir.
We got victims involved. I'm accepting the plea to suspend, accepting the plea to distracted driving. I'm going to defer the sentence on the. Well, I'll just fine you right now on the distracted. That's fines and costs of $195. Okay?
Yes, sir.
And then we'll set a sentence date. We have to notify the victim since there was an accident. They have the right to come in and seek restitution. I just want you to know that. When are we going to do this, Lisa?
December 3rd at 8:30.
December the 3rd at 8:30. Do I need to have the file taken over to probation for them to notify the victims? Is that what we're doing on these? Remind me.
Yes.
Okay, so we'll take this over, John. Make sure they notify the victim.
Judge, can he have a little bit of time to take
Pay that by December 3rd. Okay, can you do that?
Yes, sir.
And that's $195.
Just come in.
Well, he'll be here December 3rd. He could just pay that day. So however he wants to do it. Okay? I need some stickers up here, please. Do we have any sticky pads or whatever? Yeah. Oh, here I get it.
Right now.
I'm sorry. What'd you say, Lisa?
Oh, I'm sorry, Judge. I wasn't muted.
That's okay. notified. So take this over there, John, to probation. And you can pay that by December 3. And if you don't have the money December 3, you just ask for more time when I sentence you on the suspend charge, okay?
Okay.
Good luck. Thank you. Go down the hall and get your new notice. Thanks. Daly, Deborah Jan Daly, 25B149488A and B. And so good morning again. Your name.
Thanks. Attorney Mike Baldwin, House Counsel for Miss Daly. Miss Daly, when you approach the podium, if you could just please state your full legal name. Thank you. Take your time.
She's going to plead on the suspense. She's going to plead to distracted driving. They're going to dismiss
There's an added count of distracted.
correct. And they're going to dismiss the original charge, disobey traffic signal, right?
Yes.
Is that what you want to do, ma'am? If you plead guilty here to the suspend, the possible penalties again are up to 500 fines, 93 days jail, costs for all those 2 points. If you plead on the distracted driving, that's 0 points. You understand that?
Yeah.
And then if you plead on those, I'm going to dismiss the count to disobey a traffic signal. Do you understand that? I can't hear you.
Yeah.
Did you sign the advice of rights and read and understand the rights here today?
Yeah.
You got to keep your voice up.
Yeah, I do.
If you plead guilty, you're going to be giving up all those rights and we're not going to have a trial. Do you understand that? To the charge to drive while suspended, how do you plead?
Guilty or not guilty?
No.
Were you operating a motor vehicle on Gibraltar near Fort in Brownstown, September 20th, 25 at 12:14 p.m.?
Yeah.
Was your license suspended?
Yeah.
Are you on probation or parole? Was that revoked too?
Yes.
Why is everybody running on revoked licenses? Anybody force you to plead guilty? Are you on probation or parole right now?
Judge, this is an accident as well.
I know, so I have to order restitution on this one, or at least notify the victims.
One of them's a hit and run. I don't know. There's no information as to who that person was.
All right, sentencing date, I'm gonna accept your plea, and again, to the charge distracted driving, do you plead responsible or not responsible? I'll set a sentencing date. We're gonna do the 3rd again, Lisa,
Yes, 8:30.
at 8:30 in the morning. We have to notify the victims on this one too, John. So tell the ma'am, I'll just defer the sentence on the other case. We'll set that sentencing on the distracted. Sentencing on that case will be December the 3rd at 8:30. Do you understand that, ma'am?
Yeah.
I wish you well. Good luck.
He's not going to impose anything. He's going to wait and do it all at the same time.
Okay?
And he'll be your date will come. Thank you. Yes.
Thank you.
Okay, I'm going to keep working the products, Judge. We got a couple more.
You got a couple more? All right, I'll be waiting. All right.
None of these. There's a lot of no-shows today. So we're already at 10:30. And some of these people are here, I don't know if I can see so. Okay, but he was with Alden. It's fine, it's fine. Okay. Ready then. Helps for the people.
Edward Lucas for Jack McNally, who is approaching.
Jacqueline Murray?
I knew that.
I know.
Okay.
Your Honor, this case has been around for a little bit. There's been a lot of moving parts, and I don't think we've gotten to a resolution yet. So I've been asking for an adjournment. Short of that, I'd just be asking for a final settlement.
Well, why don't I When did I set it for a final settlement conference? We had like a lot of adjournments.
Okay,
That work?
Do you have time?
Sure. Apparently that's a no. I'll give the adjournment rather than setting up the final settlement conference. Young lady, do me a favor. You've been up here before me, what, a gazillion times? That's a number. You've been here, right? Of what I know of all of your cases, listen to your attorney and go in that direction. That's going to be the best for you. I'm just going to tell you that. I mean,
Okay.
you'll make up your own mind, but I think you're trying to do stuff that's just going to be disastrous for you. Keep going down the route that you're going down. You hear me? Okay.
Thank you.
The way you've been living your life, when you don't have people to kind of help you choose, that hasn't worked out too well.
I understand completely.
Right?
Yeah.
Because that's why you're before me in green right now. So maybe listen to somebody else, do something. It may sound like hard work, but in the long run, it's going to be the best for you. And I wouldn't say that if I didn't think that's true. All right. I'll adjourn this out to December 17th, 2025.
Thank you.
Thank you, Your Honor.
And I'm getting sick and tired of seeing you. No, I'm kidding. I'm kidding. I'm kidding. I just had to throw that in there. Court calls the case of the people versus Rick Urtuso.
Judge Fellows for the people.
You went to the restroom. Can you pass for a second? I'm sorry.
Burgess, man. Oh, yeah. I was going to come back. You knew that. Fine. I'll pass.
Thank you.
Court calls the case, people versus Alicia Allen.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Lauren Perny on behalf of Miss Allen. State your name for the record, please.
Alicia Allen.
All right, I have before me a plea form that indicates she's going to plead to an added count 2 of allowing an ineligible driver to operate a motor vehicle to 90-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right, very good. May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Alicia Allen.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days incarceration, a $100 fine plus court costs. Do you understand that?
Yes. Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You had signed an advice of rights form. Is that correct?
Yes.
Any question about any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Which one?
Probation.
Okay. Were you on probation at the time of this offense?
Yes.
All right. I do have to advise you then that this could be considered a violation of probation. If it is, the other court could sentence you to the maximum allowable under that other charge. You understand that?
Yes.
Still wish to plead guilty to this charge?
Yes.
Anybody promise you anything other than what's been stated here today on the record? Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe you're guilty?
Yes.
All right. On the date of February 27, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes.
Counsel? Well, I do have to advise you that between the time of sentencing and the time of this plea, if you commit misconduct as defined in the Michigan court rules, court would not be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Okay.
And have I complied with the court rule?
Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Your Honor, regarding sentencing, if I may.
Can I stop you? No, go ahead.
Ms. Allen has been in custody for 38 days, correct? She is being held on a felony. Her next court date is before Judge Mood on December 1st. So she'll be in custody for at least another, what would that be, a week and a half, depending on what Judge Mood does. She's asking for a credit for time served sentence.
Why would I do that?
Because she's been in for a while. She resolved the case. She's probably going to go to treatment when she gets out. It's a lot of money. Shall I stop there?
No. You want to keep going, you just keep going.
I think that's all I got.
Wow, ma'am, anything you want to tell me before I do a both sentence?
No.
All right. Not going to ask you that.
There.
All right. Fines and costs just go to the minimum $125. 38 days in jail, credit 38, sir.
Thank you.
Thank you.
Court does call the case of the people versus Latrell, Washington.
Conrad Siller on behalf of Pittsfield Township.
People. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Washington. I'm not sure if Mr. Washington is present. I've reached out.
He is.
Oh,
Latrell, Washington.
Yes.
State your name.
Latrell Washington.
All right, you need to turn on your camera.
Yes.
Thank you. All right, what are we doing?
you know, I have not had contact with Mr. Washington, so I requested adjournment. Last year, I asked Mr. Washington to call and update his phone number. I'm not sure if he did that, and I'm calling the new phone number or the old phone number. So, Mr. Washington, if you've gotten my calls, call me back. If not, call the public defender's office and update your contact information.
Oh yeah, I actually updated my number already.
When?
I updated my phone number after the last court date.
Algeria, December 3rd, 2025, 9 a.m. Bond continued. Make sure they've got your number.
Okay.
And an email.
Okay.
All right. Otherwise, I'm going to make you come down here and they'll get it right from you.
Okay.
Thank you. Bond continued.
All right.
All right.
Court calls the case People versus Sincere Godwin.
I just felt this for the people.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Godwin, excuse me. State your name for the record, please.
Sincere Godwin.
Thank you.
Your Honor, we're requesting an adjournment to view the media together. It's quite voluminous in this case. Mr. Godwin is being held on a Judge Conlon case. He sees Judge Conlon today. We believe he's going to be released today, if that matters to you for the next date.
December 3rd. Will that be enough time for you to get through all the media? You're indicating that it's a lot. You don't always do that. I mean, I can give you the 3rd or the 17th if you really think he's going to be released.
I'll take the 17th if that's okay.
All right.
Thank you.
December 17th, 2025, 9 a.m. Bond continued. Of course, Miss Perrini, anything. I don't know why I'm being so nice to her.
I appreciate it.
Okay.
Court recalls case People versus Rick Artuso.
Good morning again, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso, who's approaching.
Your name?
Rick Artuso. Your Honor, he's being sentenced in front of Judge Conlon on December 3rd at 1:30 PM. I was going to ask for a date after that. Ms. Feltus, I believe, is in agreement with that.
That's correct, Your Honor. I don't know, for some reason, he didn't screen when he was in custody, so it got adjourned.
That's correct. They delayed the PSR for some reason, Your Honor. I don't know why.
December 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the People versus Joseph Griffin.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Griffin. Mr. Griffin, state your name for the record, please.
Joseph Burton Griffin, Your Honor.
The corporal gives tell you got to move, lady.
No, he said.
Oh, no, I'm just kidding. I'm just saying how I saw. All right, no, go ahead.
I'm always in the way, so he gave me the right of way. Your Honor, this case is a drug paraphernalia case. It can be resolved if Mr. Griffin goes to treatment court, or not treatment court, drug treatment. He is hopefully going into drug treatment court. So we're asking for an adjournment for all that to take place. He has a couple of cases set before you tomorrow on the PCC docket.
So are they trying to get him into felony drug court or?
Yes.
Is that what?
Yeah.
Okay.
And he has releases on, I think, all of the other cases, and we'll get paperwork into you if
To release on this one.
Mr. Stiller agrees to release on this one as well.
I'll leave that to the court's discretion.
All right, thank you, Mr. Stiller.
Yes.
I'll adjourn the matter then to, well, has he started that process?
He's
No.
been accepted.
Oh, he has.
He's releasing also.
Yeah, he's been accepted into the program.
The felony drug treatment court.
Yes.
Because
Okay.
he's also releasing it.
Well, why don't I would do the 3rd, but you think we need the 17th to get everything wrapped up?
So the other complicating factor is he has a hold out of Wayne County. So that's got to be resolved before he can be released here. And obviously getting a hold of Wayne County can be difficult. So we're working on that. So I don't know if we'll get,
Why don't I do this? Let me make it December 17th, 2025, 9 a.m. If for whatever reason, everything gets worked out before then, contact Ms. Weidling and we'll see if we can move it up on the docket for him. Fair enough.
That's good.
Okay.
Thank you.
Thank you. Court calls the case of the People versus Michael Adkins.
Pastor Feltus for the People.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Adkins. Mr. Adkins, state your name for the record, please.
Michael Adkins.
Your Honor, regarding the pretrial, I suppose I asked for an adjournment. We're still in negotiations. And then there's a bond issue we should address as well.
Yeah.
So Mr. Adkins had some missed tests and saw a positive test for alcohol. Regarding the missed tests, we have been in touch with the place that he's been testing at in Flint. It seems like there's a little bit of delay in getting those results here. For example, that there was a test on the 31st that when we were here on the 5th was said it was missed. He did test on the 31st. That result is now on that report that was sent by Community Corrections. So we're trying to work out.
Is the alcohol?
Yes. So we're trying to work out the kinks on the delay on getting the test to Community Corrections. So that's the first piece. The second piece is the positive alcohol test. I've had multiple conversations with Mr. Adkins regarding the positive alcohol. I think today he would like to admit to the violation with a bit of an explanation. He is, I think Mr. Adkins' road to sobriety is a pretty long and interesting one. He was addicted to opiates. As of last year, he relapsed, but before that, he was clean for about 3 years. He was completed inpatient treatment. He was working as a counselor at a sober living house here in Ann Arbor. He was a sponsor. He had worked through the steps multiple times. So he's very familiar with substance abuse addiction and the struggles and journey that can take a person on. He obviously admits that they relapsed last year. Again, he struggles with opiates, and he's been clean from opiates now for over a year. And is getting back into that sobriety journey. He is going to AA weekly, and has moved from Ann Arbor, where his primary problem was, to Flint, so he can he's living with his brother, who's also 9 or 8 years sober, and re-enter that sober living lifestyle. So Mr. Adkins again admits to the violation. At the last court date, the court ordered him to come here to test in person. He did. The court ordered also for him to come in person today. He explained to me that his mom drove from Saginaw to Flint to pick him up and drop him off here. He's not trying to run from anything. He wants to take accountability for his actions. And I think he's doing that by admitting and trying to work through all of this. So I don't know if you want to say anything in addition to that, Mr. Adkins.
Your Honor, I take full responsibility of the positive alcohol test. I go to NA and AA meetings weekly in Flint. And I just want to not lose my job from incarceration so I can continue to, pay for what I need to pay for and so on and so forth.
He's willing to step up.
But has he taken the test? I mean, I got missed test and unable.
So
I don't have him testing.
There was an unable, I can't remember the dates off the top of my head.
November 12th.
Last week, he said he did go in the 13th and test to make up for that 12th. He did show me a PDF of those results, which were negative. It says on them that the sample was taken the 13th and it was received by the testing facility. The results were received by the testing facility on the 17th. And so he did test on that date. He did test on the 17th.
You're saying he did?
He did. I think here in community, maybe the difference is here, the results are done immediately at community corrections, from my understanding. It seems like at this testing location in Flint, they are sending the tests out. And that's how we get the sample taken on the 13th and the result coming in on the 17th. And that's delaying those results getting to community corrections, which is delaying the results getting to us. So I think that's part of the issue of the delayed or the missed tests that are reflected on our reports. But then, like I said, there was one that said he was missed on the 31st, and now we'd have a result for that test. So it shows that he did test, although it is a positive test.
Your Honor, based on the report, I trust defense counsel representations, of course, but based on the report that's before me, and I'm looking at, in 1 month, we've had one compliant test, which was November the 7th, which was a test that the defendant had 2 days of notice for. The court recalls on November the 5th, when we were here, the court ordered him to test by Friday. So he had 2 days to go to that test. I believe the science and what we're seeing here is pattern of alcohol use and refusals or missed tests. If the court recalls the time of arraignment, I let the court know that this was not that long ago. And the defendant was found passed out behind the wheel of his vehicle, had to have 2 doses of Narcan to even come around at all.
and was discovered to have 47 nanograms of cocaine in his blood. I'm extremely concerned for public safety. I think it's great that he's moved in with his brother, but clearly that's not working because he's been residing there since the pendency of this case, if I recall correctly. And we're having these tests that are showing ETG. We had one for THC, and we're seeing non-compliance. The concern of the people at this time is public safety. And I'd ask the court at this moment, remand him for the bond violation. If the court is inclined to release them, I would request a scram tether, as well as the continued intensive supervision for drugs. That's also an issue here.
Anything else?
Anything else from you?
No, ma'am.
So here's part of the problem as I'm seeing it. And yes, I'm concerned about public safety, but I'm also concerned about this defendant. The thing is, you know what it takes to get yourself sober. And I'll just put it in a colloquial sense that what you're doing right now is you're just half stepping. And you know that. You know that you are not doing what it takes to get yourself there. And that's why things are coming out and working this way for you. You got to make up your mind, young man. If you want to do it, you know how to do it. You've done it. You just have to do it. This half process for you is not going to work. And you got to figure that out. But if you think that what I'm going to do while you're in the process of trying to figure that out is allow you to be out there, be in a position where you decide to get behind the wheel because you're doing whatever and then end up killing somebody, that's not going to happen. So what I'm going to do is I'm going to adjourn this to December 3rd, 2025, 9 a.m. He figure out in that time what he wants to do. But at this time, his bond is revoked, defendant remanded. Court does call the case of the people versus Murtada Al Allah.
Ashley Phelps for the people. Good morning, Assistant Public Defender Attorney on behalf of Mr. Al Kala. If you here, sir, state your name for the record.
Thank you.
Your Honor, the last hearing, Mr. Al Kala was working on going to Secretary of State and getting his license. I'm not sure if Mr. Al Kala has an update on that. If I request an adjournment.
Did you get your license, young man?
Not yet.
Why?
I went and had a talk with the lady I did back like 2 months ago, and she's just, still looking at some stuff to see why, and I'm still waiting for her to give me a response back.
You need to go down there and figure it out. I'll adjourn this out to December 17, 2025, 9 a.m. I want to see some progress on this. Otherwise, we'll have to deal with it a different way.
Will do.
All right. Thank you. I'll continue.
Thank you, Your Honor.
Court calls case People versus Marcus Jackson. It's an arraignment. Your name, sir?
Marcus Jackson.
All right. Sir, you are before the court on a new complaint that alleges that on or about August 17, 2025 at the location of 2376 Carpenter Road, that being the Quality and Parking Lot, that you did operate a motor vehicle while intoxicated. You understand the nature of that charge, sir?
Yes, sir.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could also order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the costs of the prosecution, as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
All right. First question I have for you is, do you wish to be represented by an attorney on this matter?
Yes, sir.
This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Jackson, we would waive any further formal reading of the complaint. My client stands mute and I would ask for an adjourned pretrial date, please.
Pending every way formal reading, standing mute, court will enter a not guilty plea. I will adjourn this matter to December 3rd, 2025, 9 a.m. As to bond in this case, alleged BAC.
0.126, Your Honor, the defendant was found passed out in his car with the vehicle running in that parking lot. And Your Honor, from what I can tell, there may have been a prior offense from the state of Georgia, but I'm not able to confirm that at this time.
Is this the only thing he's held on, or?
Your Honor, Mr. Jackson indicates to me that he has other matters that are holding him right now. So I would ask for a nominal bond the court would allow.
That's correct, Your Honor. I see an open plea 3rd, as well as potentially another OWI.
Got it. Set his bond at $2,500, 10% bond. Under the standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drug. I will order that if the defendant is released, he is to report to the Department of Community Corrections placement on a SoberLink testing device. I'm also going to order drug testing at 2 times per week.
The next date was December 3rd.
Yes, ma'am.
Thank you so much.
All right. Thank you.
Thank you, Your Honor.
When did he get here? There's nobody behind you. You know who I'm looking at. When did you get here? And stop. Don't bother Miss Valtez. He's busy. So move your chair away. All right. Good. Court calls the case. People versus Divine Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
And Assistant Public Defender Natalie, on behalf of Ms. Martinez, I have been informed that she is at Washington County Jail, but I've been informed she doesn't, it's not coming up.
She doesn't. She's refusing to.
I think that's the third time. That's the third time.
1, 2, 3. This is the 4th.
4. I missed one.
Yeah.
If I may just say for the record, she is being held on some other matters, and Ms. Cannon from our office has been working with jail services regarding her mental health treatment and then possible release to treatment. But she is being held on other matters at this time, but there are pieces to things. So I would ask for, we were going to be requesting an adjournment anyway.
December 17th, 2025, 9 a.m.
Thank you, Your Honor.
Court does call the case of the people versus Zion Jones.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Jones. Mr. Jones, state your name for the record.
Zion Jones.
All right, what are we doing?
Yeah, we're requesting an adjournment. Mr. Jones would like to see if he can get his license. He is being held on a $25,000 bond. I think it's up before you tomorrow. Do you have court tomorrow? So I guess we'd like to see how that shakes out if he gets out of custody.
December 3rd, 2025, 9 a.m.
Thank you.
Bond continuing investment. Thank you. Court does call the case of the people versus Hassan Isa.
Ashley Feltus for the people.
Oh, why'd you put his case up?
Well, it was scheduled for 9.
No, Mr. Issa's fine. It's you. That's the problem.
Always a pleasure seeing you, Judge. Your Honor.
State your appearances?
Yes, Hugo J. Mack, Your Honor. P300997 for the record, with Mr. Issa. Your Honor, I have been in touch with the prosecuting attorney's office, but I have not had a chance, especially to speak to the prosecutor. We may well be able to resolve this matter today.
Yeah, Mr. Mack sent me some documentation related to his client's status at the time related to his vehicles that I want to go through with the trooper and give a little bit better understanding about what happened. So I'm requesting a little bit of time to do that.
Okay. So it doesn't look like it can be resolved today, but you've gotten the information to her, correct?
That's correct.
All right.
Yes. So, Your Honor, I'm not sure what the next available date is. If it's December the 3rd.
That's my next available date.
That's okay. I've got like 7 matters in front of your colleague on 14A2. So it would.
For Judge Barr?
Yes. So
does he want to see you?
We could do it. I don't know. It's.
I'm just asking.
You know, Judge,
I'm just asking.
Jury's still out on that one.
Okay. All right. I'm just checking.
So we could do it that
Are they in the morning or what?
It is scheduled for 9 o'clock. So, and I anticipate those matters going real quick, Judge. So could we get 10 o'clock?
Yeah, you always anticipate things going quick and you start.
Can we get 10 o'clock on that day? Is that possible for you?
So every time he comes up here, he wants to pick his block. And what do I tell them? No, that's not how it works.
Oh, okay.
I tell you that all the time, Mr. Mack. Here's what I'm going to do.
Yes, sir.
I'm going to set it for December 3rd, 9 a.m.
Okay.
Now, when we divide it into blocks, we will see where we can put you.
You know, Judge, that's why I carry your pitch with me at all times.
Bond will continue. All right. If you've got a scheduling issue, Ms. Weidling will be more than happy to try to accommodate. Can't guarantee it, won't guarantee it.
Okay.
But if you let her know by email, okay, do not call her because I told her don't talk to you.
Okay.
All right.
A long list of knowing fans, I might add. Okay.
All right.
Okay. Thank you.
That's right. Thank you, Mr.
Okay.
Here.
I'll let you know.
Court calls the case, People versus Jeffrey Ostermiller.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Laura Perry on behalf of Mr. Ostermiller.
He is here. Sir, state your name.
Jeffrey Ostermiller.
Your Honor, we are requesting an adjournment. Mr. Ostermiller has a case in the 15th district court that is going to tomorrow that we'd like to see what happens on first.
Got it. I'll adjourn this in to December 3rd, 2025, 9 a.m. Where's your invite indicates. Okay. Thank you, Mr. Ostermiller. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus Shondell Barrett.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Laura Perry on behalf of Ms. Barrett. Ms. Barrett, state your name for the record, please.
Shondell Barrett.
Thank you.
You're welcome.
I believe we're close to a resolution. I know Ms. Barrett wanted to just cross some T's, dot I's. But so I'm asking for an adjournment just so we can make
No,
sure.
I actually texted you yesterday and told you it was okay to just go ahead and do what we were initially talking about doing.
Okay.
Yeah.
So we do have a resolution then. I just need to have you sign some paperwork, Ms. Barrett.
Okay.
So we'll.
December 3rd, 2025, 9 a.m.
Oh,
Okay.
no. I
What do you
was
mean,
just
no?
signing papers. I mean, no, I'm just saying I thought we were signing papers. Like, we still have to come back, or is it something different that's happening? I'm confused now.
Okay, no, I adjourned it out to December 3rd. And that way, that's going to give you and your attorney time to go through the paperwork that you need to sign to get the agreement all
Oh,
set.
okay. Okay.
Okay? Bond will continue. Thank you. Court calls the case, People versus Thomas Bittner.
Okay. What is going on now?
Hold on a second. Slink in. All right.
Ashley Feltus for the people in the Bittner matter.
This is the public defender Lauren Perry on behalf of Mr. Bittner. Your Honor, we have come to a resolution.
Here.
He's not, but he has given me permission to admit to the civil infraction with no proof of insurance on his behalf.
Got it.
And I would add that as account to 257328, Your Honor.
And Ms. Perry, on behalf of your client, do you bear responsibility to the fact that on September 24th, 2025, at the location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, that upon the lawful request of an officer, defendant was unable to show proof of insurance?
I did.
All right, court will accept that admission to that charge. Fines and costs of $155. When can he pay that?
He's asking for 2 weeks.
2 weeks. They pay it by December 12th, 2025. Thank you. Court does call the case of the People versus Candace Brooks.
Feltus for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Your Honor, I'm not sure if Ms. Brooks is here. She was adjourned to the state, but then was not on the docket that was sent out. I did not. I think there was I don't know if it was a clerk's. I frankly, I did.
She was not on her docket, you're saying? I adjourned it out today.
That's correct. I did not contact her about today is what I'm trying to say. So I don't know if she.
December 3rd, 2025, 9 a.m.
Thank you.
Otherwise, we were going to be here till tomorrow with your explanation. Court calls the case, People versus Leslie Brown.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brown, Mr. Brown, excuse me.
Sir, can you state your name?
Leslie Brown.
Thank you.
There has been an offer extended. Mr. Brown just wants a little bit more time to consider that offer.
Turn it to December 3rd, 2025, 9 a.m. All right. Bond will continue. Thank you, Mr. Brown.
Thank you.
Court calls case People versus Naria Clark.
Ashley Feltus for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Clark, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Naria Clark.
Thank you, Your Honor. There is a civil infraction resolution in this matter. Ms. Clark will be admitting to the civil infraction of no proof of insurance.
Out to 257328, no proof of insurance, and this happened, successful plea to count two.
And Ms. Clark, do you admit responsibility to the fact that on August 8th, 2025, Gulfside Road, Pittsfield Township, Washington County, State of Michigan, that upon the lawful request of an officer, you were unable to provide proof of insurance?
Yes.
Court will accept that admission to count two. Count one is dismissed. Fines and cost of $155. When can you get that paid?
In 2 weeks.
All right, pay it by December 12th. Okay, 2025.
Thank you.
All right, you're welcome. Take care.
Thank you, Ms. Clark.
Court calls case People versus Theodore Edwards.
Ashley Feltus for the people.
Assistant Public Defender on behalf of Mr. Edwards.
Theodore Edwards.
Okay. Thank you. You got it.
Yeah.
Okay. All right. What are we doing?
I would request an adjournment, and then also I would request that Mr. Edwards contact the public defender's office to update his phone number. The phone number I had for him was disconnected. So maybe he can reach out.
Good morning. I'm going to address the sentence in the matter of, says it's on. We're going to address the sentence in the matter of People versus Sarah Marie Wainwright. This matter was set for Monday afternoon, but we ran out of time. The matter was rescheduled for this morning. Defendant had difficulty getting here again today. I guess she had a flat tire. But we are here. We're not terribly late. And I was trying to wrap my head around this case. Matt Huff is here from the probation department. He's prepared the screening report. Prosecutor Camfield is not available today. I don't think they're going to send anybody else. But the facts in this case were I'm not sure what the right word is, difficult and confusing. The defendant was very disoriented and disabled relative to her blood alcohol level. She has a version of the incident. The man whose house she was at has a different version. And then she was very disoriented at the time she got arrested. Mr. Huff has prepared a screening report, and we were ready to go, but Miss Wainwright was quite late and we all had other obligations during the lunch hour. I didn't get any lunch that day. But we got lots of time this morning. Mr. Hayes' case is pending, but we can wait to address that matter. So Ross, what do you want me to know here?
Well, I provided a medical form from July the 1st of this year in which Ms. Wainwright did attend the physician's office. She provided essentially a similar account of her injuries, what led to them. Just offer that to kind of corroborate her statements regarding the, I suppose we'll call it a flight from a risk or perceived risk that she experienced. Ms. Wainwright has a very limited criminal history, as outlined in the pre-sentence report. I suppose things fell apart in August of 2024. She had been separated from her husband. They were attempting to reconcile. She was traveling down a roadway. Husband was going to meet at the same place, passed her in his motorcycle and struck another vehicle and died in front of her. And at that, this happened in her home area of Garrett, Indiana.
Okay, but not related to this.
Not related to this matter.
Yes.
But that's when things began to be difficult.
Okay.
So we have this traumatic experience. And then about a year later, she decides to get out there and makes a date after chatting online. She comes up here to the Lake Templine area. The date doesn't go well. There's drinking and carrying on. And as Ms. Wainwright reports, there's some domestic violence type activity. Whatever it was, I believe her, she felt the need to flee, and she did. And I think that might account for some of the disorientation relative to the alcohol level, experiencing this, and probably a flood of complicated emotional responses to this first date after the death of a partner. And she crashes into the swamp after I think she missed a stop sign or skidded through a stop sign. So thankfully nobody was injured in this accident. There was not another car involved. She was cooperative with the police. She's been cooperative with me. We met right away in my office as soon as she was charged. We went through all of this. She's not a big drinker, as she reports to me. This is a date gone sideways. And I think that it's important to separate the facts of the case and the charge from the facts of the process after the charge. And I think that one of those is bothering possibly Your Honor more than the other. We agree with Mr. Huff's guidelines regarding the incident itself. I don't know that probation with somebody that lives this far away and has such a limited criminal history and a low BAC would be beneficial. We understand the accident is an aggravating factor, but there's no indication of extreme driving or high speed other than the accident. And I would suggest that should we follow Ms. Wainwright's account, a strong focus on the rear view mirror may have been a contributor to her failure to stop at the stop sign. So I'd ask the court to adopt the recommendation and allow Ms. Wainwright to pay her fines and costs, move on along. She's got a lot of other life stuff going on, a foreclosure process in Indiana that she's trying to address in a pro se fashion. She's struggling, but I don't know that it's struggling because of alcohol or any other substance. I think it's a matter of being in a kind of a Job situation in life right now.
Yes, everything's going wrong. And you make a good point. We need to sentence her based on the conduct that resulted in her arrest, not the fact that I'm irritated with her because she doesn't show up when she's supposed to. She failed to show for arraignment on September 8th. She called. We tried to reset it. She said she got a flat tire here on the way here on September 10th. I'd like to see the picture that she took of the flat tire. If you'd email it to me, I'd like to do a reverse search of it. So she got a flat tire on the 10th. Then she was substantially late She kept calling, so we actually sat here for 50 minutes waiting for her. And then by the time she got here, it wasn't time to deal with it. This is a first offense drinking driving where your blood alcohol is 0.10. What troubled me about this is you went to this date with a handle, a half gallon of Captain Morgan. And certainly you were upset about what happened. You've given me this telemedicine report from your doctor back in July. Did you tell your doctor that you'd also been in a car crash?
Yes, Your Honor.
It doesn't mention that in here anywhere. And I'm old. Computer dating predates me by a long time. But I just think how reckless and dangerous it would be to just meet somebody online and then go to their house.
I've been speaking with him for a few months
What?
prior. I had been speaking with him for 3 months prior to that.
Okay, that's a different perspective. You thought it was fine. I think it's dangerous and spooky. And you go there with a half a gallon of Captain Morgan. Anyway, his version of what happened and yours are different, but it's not charged as an assault. It's just kind of the background to this situation. Judge Stutzman had a case where somebody, it's famous, he shared it with the other judges. Somebody sent a picture of a wrecked car, said she was in an accident on the way to court, and he reverse searched it, and it was a stock photo that she got off the internet and was not in an accident on the way to court. Matt, I'm going to forward it to you. Ask you to do a reverse search on those. All right. But before you do that, I'd like your input. You and I have discussed this. She seems like a nice young woman. Everything that could go wrong is going wrong. If you ever read the book of Job, there's a lot of bad stuff that happens to Job. Everyone he loves dies. He loses everything he owns. He gets boils.
Hi, Ms. Trander, what are we doing?
Your Honor, my understanding is Ms. McCabe is going to be changing her plea to count 1 and count 2. Possession of cocaine and possession of heroin, both as felony 5s. State will ask for dismissal of counts 3, 4, and 5. My understanding is that we're going to request a PSI. As part of that PSI, I would request that an evaluation be conducted for an appropriate placement at CBCF and continue the case for sentencing.
Mr. Moss, is that accurate?
Yes, Your Honor. She's actually she met with Mindful Healing yesterday, right before I got there. Yeah. And I think they have a spot for her.
Okay. All right, Ms. McCabe, they're telling me you're going to change your plea to guilty to 2 counts from the indictment. Before we get to your change of plea, I am required to go over some things with you, okay? Yes?
Sir.
You need to answer out loud?
Yes, sir.
How old are you?
31
How far did you go in school?
to 11th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Moss?
Yes,
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on today?
No, sir.
I have in front of me a document, it's called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read it and go over it with your attorney?
Yes, sir.
Do you feel like you understand what it says?
Yes, sir.
This document says you're running a plea of guilty to one count of possession of cocaine as a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The second count is one of possession of heroin, a felony of the 5th degree. That also carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. Neither of them carry mandatory prison sentences. Do you understand the maximum penalties?
Yes, sir.
You're also subject to a discretionary period of post-release control, which means if this court sends you to prison on these charges, upon your release, the Adult Parole Authority may supervise you for up to 2 years. If you violate those rules of supervision, the Adult Parole Authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury. They are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense. And if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Ms. Tranter?
On or about October 2nd, 2025, in Morgan County, state of Ohio, defendant was in possession of 0.753 grams of cocaine, Schedule 2, as well as 0.63 grams of heroin, a Schedule 1 controlled substance.
Mr. Moss, anything on those facts?
No, Your Honor.
Ms. McCabe, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
Yes.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I will order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. Anything else, Ms. Tranter?
No, Your Honor.
Mr. Moss?
No, Your Honor.
All right, thank you all.
Okay, so
Jen, I'm going to go meet Renee for lunch. I'll be right back.
Doesn't does kind of have a marginally happy ending, but anyway, she's struggling to get through her way in the world. And this was not a good plan. And well, go ahead with your thoughts on the matter.
And the court has really expressed most of my sentiment. There's so much going on in this case, it makes it very difficult to decipher what's going on. And I think the brunt of my recommendation is filtered through the lens of the new legislature, which is this sort of presumption that individuals with no criminal history and minor case facts are just supposed to be presumed to not come back. Mr. Truckee also indicated she lives an hour and 15 minutes away in Garrett, Indiana. And all of those facts don't mean that somebody doesn't have to suffer any sort of consequence for their action. But every time I did my best to separate what we'll call maybe a gut feeling about what's going on with somebody versus the case facts that are presented, and then the plausible explanation for why they're there. You know, for example, the car accident. When you look at the case facts and she doesn't have shoes and she's in this accident, she's not from around the area. It is entirely her blood alcohol content only being a 0.09, yet her, as you'd indicated, you know, her behavior was more indicative of somebody who was probably twice that. Makes sense that somebody would be perhaps in some sort of crazy situation, so to speak, while also intoxicated. And so you get that amplified effect on display. It doesn't mean that that's what happened necessarily. But like I said, the amount of case facts present in this just make it hard to decipher it. So my recommendation was to follow the presumption. And again, that was independent of the rescheduled arraignment, the missed attorney pretrial, late for sentence, and then a few minutes later for the rescheduled sentence. But I struggle with this one as well.
Miss Wainwright, what would you like me to know?
After my accident, and I was released from jail without shoes. I had no phones. The police didn't get any of my items out of the vehicle like I had asked politely. I had a wonderful woman who helped me. Her name is Jen Brandeis, I believe. She told me a lot about you.
It would be Jan Brandeis.
Oh, Jan? Oh, she goes by Jen. She on her Facebook.
Okay, well,
She
maybe.
had wonderful things to say about you. But she was a guardian angel who helped me. After jail, she walked by me on a bench and she got me shoes. She got me dressed and she got me a ride back to Garrett. It was a rough day. She worked with me all day. And if it wasn't for her, I don't know what I would have done.
That would be the second part of the Job story, Judge.
Yes. Well, they did go talk to him, but not till the next day. And they never really investigated as an assault. You were both drinking. The same person was tangentially involved in another case here this month of November, where someone else was upset with him, asked for a personal protection order.
He was trying to rape me that night.
Okay, I'll just take that at face value. That certainly would explain why you were so distraught. But don't do this anymore. Don't go
and I won't.
meet some strange man at his house.
A lot.
It makes the hair stand up on the back of my neck. Let's go check those images to make sure we're not getting played here, and then we'll address this. Mr. Hayes?
Yes, Your Honor.
Good afternoon or good morning. You're in the right place and it is the right time. I'll be with you in just a few minutes here. We got a little bit delayed on the case ahead of yours. And your mother is also here. as an interested party. So I haven't forgotten you. We're just doing something else. So stay right where you are and we'll address your case in just a moment.
Okay, Your Honor.
All right, I'll put you in the waiting room. Now, this has been reduced to impaired driving. Impaired driving will allow you to keep a restricted driver's license to drive back and forth to work in the course of employment, treatment, court, other limited purposes. That's in Michigan. I'm not exactly clear what Indiana is going to do. Sometimes in the past, Indiana had treated impaired as a OUIL. But the way it's supposed to work is you're supposed to get a restricted license rather than suspended. I hadn't looked at these pictures. They look legit. It looks like Shum Road. Do you carry one of those in your car or somebody stopped to help you?
I had somebody stop, but I did bring that with me this morning just in case.
You've been having problems with your tires?
Yeah, the back too. That's kind of the replacement vehicle I ended up getting after my.
Do they have aluminum rims?
I couldn't tell you. There's a lot of issues wrong with that vehicle.
Well, I had a car with aluminum rims. I couldn't keep any air in the tires.
That one, I've had issues since I bought it.
What is it?
What vehicle? It's a 2016 Chrysler 200. I've got the tranny slipping as well.
Chrysler 200s are famous for having bad transmissions.
I found that out. And then I found out it had been wrecked twice as well that they didn't tell me prior.
I think these pictures are legit. We'll find out. Mr. Huff referred to the new statute, relatively new, when the Criminal Justice Reform Act. There's a presumption in a non-serious misdemeanor that there won't be any jail or any probation. You don't live here. You live a long ways away. You've had a hard time getting here at the time and date that you're supposed to be here. I don't know why you just didn't show up on the first one. I don't remember, but you just didn't come.
I remember why now.
Why?
My mother I told you she had stage 4 leukemia. She had fallen that day and I took her to the hospital and I had called and let them know. That was the first time.
Well, you called 2 days later. Let's take a look at your ticket and see what it showed. They sent you a summons for 9/8 at 8:15 rather than issue a warrant for your arrest. And you didn't show up on 9/8. You called on, no, you did call on 9/8, called a reset. Reset for 9/10. Defendant called had a flat tire on the way, reset for 9:17. That's the time you were several hours late. You got here like 2 o'clock in the afternoon. I looked at the pictures after I sent them to, they look legit. I'm assuming that they didn't.
They appeared authentic.
What?
They appeared authentic. I mean, the surroundings are.
Yes, our neighborhood, our streets and
Same.
her car.
Same, yeah.
So there's not a stock photo of somebody pumping their tire. All right. I don't want to belabor it. I've said it, but you put yourself in a very bad situation. The other thing that scares me about this is you were going to attempt to drive all the way back to Garrett, Indiana. You spent a night in jail. You lost your shoes. Plus one of our citizens who helped you get squared away. I don't like people getting dumped out the front steps of the jail with no phone, no shoes, and nowhere to go. It happens more often than you think. I often ask the people, where are you going to go when you get out of jail? So you had all that as part of your punishment. Mr. Truckey's right. Just because you maybe missed my lunch twice, that's not what you're being punished for. I don't want you on probation. Or a 1-day jail credit, 1 day. This carries a $300 maximum fine, a $75 crime victims' rights fee, a $50 state minimum fee, a $100 screening fee, $150 attorney fee, and a police reimbursement. How much was that?
I don't believe one was requested, but there was no blood draw. Oh, I'm sorry, there was a blood draw. Blood draw in an accident is $255. St. Joseph County Sheriff's Department was the responding agency.
What I didn't ask, and I'll leave it hanging, is what else were you taking? Were you on medication, which might account for how disoriented you were? If you were also taking some prescription medications and mixed them with alcohol, stuff like Xanax or Paxil or things people take, which are not supposed to be mixed with alcohol. May I explain your level of?
I had taken my medication early that morning that I normally am prescribed.
What was that?
Which is gabapentin, hydrochlorozine. I take one Adderall pill, but I took those at 8 a.m. that morning. And then I hadn't taken any more medication. And so it had been over, I think it was maybe 18 hours prior to the accident.
All right. Well, I still don't think you're supposed to.
I had never been in an accident in my life. Traumatic experience had just happened.
Well, maybe that explains all of it. I'm not even going to order the victim impact panel. That comes up to $925. I don't have any bond that was posted here. Do you need a payment plan, or can you if I give you a date, will you pay it?
Payment plan would be wonderful.
Your Honor, are you including the reimbursement? I don't have the request. We didn't have noticed that the agency was seeking reimbursement.
Yes, I am.
That standard.
Let's take a look. I don't have the prosecutor to tell me. Let's look. Yes, this was a big pain in the neck. They had to go to an accident scene. They had to deal with her. They had to take her to the hospital and get a blood draw. You also had to pay to get your car out of impound. Was it totaled?
Yes.
Did you get it out of impound?
No, I didn't.
So you just lost the car as a result of this?
Yes, Your Honor.
There's an additional extrajudicial sanction. All right, yes, I'm ordering that. All right, I'm going to the courthouse to take you out.
Thank you.
I'm going to give this back to you. I don't want your medical records being in part of the court file. But I will acknowledge that I reviewed it.
We'll set your payment. Thank you, Your Honor.
Thank you.
Okay, take care of yourself, sir.
Thank you.
All right, we're about to address an expungement matter, so I'm going to stop.
Mr. Feltus for the people.
Yes, Your Honor. How you doing today? Brandon Bird on behalf of Skyler Griffin.
I'm doing fine, Mr. Bird. How are you doing?
Trying to do my slow walk again. But unfortunately, I have been trying to get in contact with Ms. Griffin. I just was appointed to the case on Monday. I was, and I would ask if we could just adjourn this matter and give Ms. Griffin one more chance to come and me another opportunity to get in touch with her.
Bench warrant will issue. Bond will be set no matter $5,000, 10%, but I won't have that issue until the 24th.
Thank you. Thank you.
Thank you, sir. Is that all you have?
No, I got one at 12. What you want to call that for two?
Court does call the case, People versus Desiree Johnson.
Mr. Feltus for the people.
Congress, on behalf of Ms. joining at the podium momentarily. Yeah, so please say your name for the record.
Desiree Johnson.
Your Honor, today's the date and time set for pretrial. The people have extended an offer which we intend to accept. I sent the court a copy of the police report yesterday, but it was after the cutoff, so we are asking for an adjournment. Unless the court would be willing to accept it, but we'll take the adjournment.
I'm taking no contest plea. I should read the report. That
would be helpful.
Cut out.
Certainly, Judge.
I'll adjourn the matter to December 3rd, 2025, 9 a.m. Bond continue.
Thank you, Judge. Talk in the hallway real quick.
Court calls case People versus Christian Dameron.
How are you doing, Your Honor?
I'm doing well. Your name?
Christian Naron. I'd like to respectfully state that I watch your videos and I respect what you do, and it's definitely a good laugh.
Well, thank you.
Thank you, sir.
A good laugh. Really?
Yeah, just like at night watching videos, scrolling, seeing you and the smile, it's funny.
I don't. Yeah, okay, I'll stop smiling. All right, sir, you are before the court on a misdemeanor citation that alleges that on or about November 1st, 2025, at the location of US 23, Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle without the proper security or insurance. You understand the nature of the charge, sir?
Oh, yes, Your Honor, I do.
All right, that is a misdemeanor punishable by a fine between $200 to $500, not less than $200, not more than $500, and up to 1 year in jail. You understand that?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Well, I want to state why.
Well, I don't want you to say anything about the case at this time.
Okay.
Yes, sir. Do you wish to have counsel represent you? It sounds like you might have an explanation or something.
Yeah.
And so do you want counsel to be able to help assist in that process, dealing with the prosecutor?
If we end up going to another trial, I'll have my attorney's in trial right now, so that's why I'm here.
All right. What I will do then at this point is I will it is standing mute. You're not saying anything about the charges. I'll enter a not guilty plea. Do you know when your attorney will be available?
I'm not exactly sure, Your Honor, but I can find out.
Well, here's what I'll do. I'll adjourn it. Who's your attorney?
Michael Levitt.
All right. I'll adjourn this to December 3rd, 2025 at 9 a.m. or as your invite indicates. And then you can let Mr. Levitt know that.
December
December 3rd.
Okay, December 3rd.
If it doesn't work for him, then he knows how to deal with that part and get his appearance in. I will set your bond at a $5,000 personal recognizance bond.
So that's December 3rd at what time?
Well, I set it at 9 a.m., but then you get placed into different blocks after we see what the document.
I have what? Sorry.
You get placed into different time segments as we see what the document.
Gotcha.
Okay, but everything is set generally at 9.
For the record, I'm gonna give my card to the defendant so he can have his attorney email me.
Thank you.
All right. So I'll do that. Standard conditions: no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal. All right.
All righty.
Thank you, sir.
Yes, sir. Thank you.
Yeah, I can't talk.
Court calls the case People versus Rashelin Diag.
You have an attorney, I cannot speak with you. Ashley Phelps for the people.
Diag,
He is here, Your Honor.
yes,
Yeah, I spoke with him this morning. He was
or
here.
Deeg, maybe.
Yes, sir.
Deeg, okay, I was mispronouncing it, okay.
Richland Digay.
Okay, Deeg, okay. Sir, you are before the court on a misdemeanor complaint that alleges that on or about July 25th, 2025, location of eastbound I-94 in Pittsfield Township, Washington County, state of Michigan, that you did operate a motor vehicle without proper security or insurance. You understand that, sir?
Yes, I do.
All right, that's a misdemeanor, punishable by up to 1 year incarceration and a fine of not less than $200 nor more than $500. You understand that?
Yes, Your Honor.
First question I have for you is, do you want to be represented by an attorney?
No, Your Honor.
Okay, what are you going to do on the case?
Your Honor, I've spoken with the counsel. I believe that we may be able to reach an agreement. I think that we may need a little bit of time for counsel to verify some information.
Your Honor, I did speak with the defendant earlier today. I advised him that I was a prosecutor, that anything he told me could be used against him. I advised him he did not have to speak with me if he did not want to. He told me he wished to, he gave me some documentation, and he had previously emailed some things to my office that I want to discuss with the trooper. So we're just looking for another date.
All right. So you want to represent yourself, sir?
Yes, Your Honor.
Adjourn the matter to December 3rd, 2025, 9 a.m.
Your Honor, for the record, would the court be willing to advise him of the perils of self-representation?
I will.
Thank you.
Sir, I've already, actually, I'm going to do December 17th, 2025 at 9 a.m. Sir, I have already advised you as to what you're charged with and the maximum penalties. I do have to advise you, if you choose to represent yourself, you'll be held to the same standards as an attorney would regarding the Michigan court rules and rules of evidence. You understand that?
Yes, Your Honor.
You understand that the court would not show you any favoritism or lack of favoritism because you were represented or not represented. Do you understand that?
Yes, Your
Honor. The other thing is that if at any point in time, and I would indicate to you that this court does not deem it advisable for you to attempt to try to represent yourself, but you're constitutionally entitled to do so. If at any time you decide that you wish to be represented by counsel, you just need to let the court know that you wish to have counsel, and the court will ensure that you do have counsel to represent you in future proceedings. You understand that, sir?
Yes, Your Honor. Your Honor, I would like to change that point and I would like to go to a point.
You'd like to go with an attorney?
Yes, sir.
Probably a wise move. All right. So this is a public defender.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Diag. We would waive any further reading. My client would stay in mute, and I would ask for an adjourned pretrial date, Your Honor.
Defendant can waive formal reading, standing mute. Court will enter a not guilty plea on behalf. I've adjourned it to the 17th of December, 9 a.m. Bond will be set in the amount of $5,000 personal recognizance bond, all other standard conditions, including no assault behavior or possession of any weapons. There should be no possession of any alcohol, recreational marijuana, or any illegal drug. All right. Thank you.
Thank you, Your Honor.
Court does call the case, People versus April Fleming.
Ashley Phelps for the people. Good morning, Assistant Public Defender Lauren Perry on behalf of this body. So Mike, please state your name for the record. Don't know why she's not here, Judge.
Okay. Bench warrant will issue for defendant's failure to appear, bond $5,000. 10% privilege, that warrant will issue immediately. Court does call the case of the People versus Daryl Frederick.
Public Defender
Daryl Frederick.
I do not have an explanation for failure to appear. The record was medically, I do confirmation was medically discharged from Sacred Heart. I do not have an explanation for failure to appear at this time. I do believe at court yesterday, in which Mr. Trucas represents him, and my understanding is he did not appear for that either. I don't have an explanation for his failure.
That warrant will issue for defendant failure to appear, bond $5,000. 10% warrant will issue immediately. Court calls case People versus Tony Gomez.
Phelps for the people. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Gomez. Mr. Gomez, state your name for the record, please.
Tony Gomez.
Okay, there it is. Got it.
So, Mr.
Sorry,
Gomez
Judge, I was trying to get my camera working.
No, you're good. You're good, sir.
Thank you.
Been accepted into the 19th Veterans Treatment Court. I believe that, so I have the memorandum of understanding is signed by all parties, then we'll send it to the courts for your review.
But he has been accepted in the Veterans Court.
Yes, his next date there is the 25th. I believe I'm trying to confirm with the probation officer, but, and I spoke with Mr. Gomez, I believe that they can do the plea there once the court signs the memorandum of understanding. So once I get it back from Judge Freshour, I will send it to your court, and then we'll send it to them. I think once it's signed.
So you're saying they will do the plea?
I believe so. I will confirm with probation.
Okay, so, all right, no, if they want to take the plea, I'm not gonna scream and yell.
Yeah.
But the question I have is, he would have to pay fines and costs to this court.
Mm-hmm.
And then any probation oversight fees would be paid to that court.
Mm-hmm.
They're gonna do that in terms of its sentencing? Because normally we do that in terms of our sentencing and just send it there.
The memorandum of understanding does say that fines and costs are paid to the transferring court.
Correct.
To the receiving court, and then paid back to the transferring court through whatever court rules. So I know
That's fine. No, and everybody does it differently, but as long as we're all set and everybody else is coming, I don't have a problem. I mean, I'm not.
Yeah, I know. It's like every time we have a specialty court, I'm like having to relearn all the rules again or learning new rules. So I guess maybe if we put it out, he'll go on the 25th
If we can't do something, then all right.
Then we can do it here on the 3rd and yeah.
So I'll adjourn this, sir. I'll adjourn this, Mr. Gomez, to December 3rd, 2025 at 9 a.m.
Judge,
All right. Yes, sir.
as soon as I go to the court next Tuesday, whatever I find out, I will contact Miss Lauren Perrine and give her an update on exactly what's going to happen between the two courts. I was pretty sure that. Yeah,
that's fine.
Okay.
They'll usually let us know that what I was stating and what Ms. Perrine was trying to clarify is that there isn't a consistent way that the specialty courts do it.
I understand.
And
Judge.
so you would have to, in some respect, come back here, take the plea, do whatever. But if they take the plea, that's fine. If they don't take the plea, then you'll come back on the 3rd and I'll take care of the plea.
Sounds good, Judge. Thank you.
Thank you. And what branch were you, sir?
Marine Corps, Judge. I served from 2008 to 2016.
God bless you. You're a Marine.
Yes, sir.
I always like having Marines. I don't know. I get a lot of Army here, and I'm like, before I asked, I'm looking at you, and I said, I bet you he's a Marine. So I was right. Sir, I just want to tell you, if I don't get to see you again, and I try to acknowledge all the veterans, I just want to thank you for your service to the country. I am well aware because you did what you did. I get to do what I do. And I'm mindful of that every day. So thank you for
Judge.
that, all right?
Thank you, Judge. God bless you guys. Have a good day.
You do the same. Court does call the case of the People versus Simone Green.
Ashley called this week. Good morning, Assistant Public Defender Lauren Perrine on behalf of Ms. Green. Ms. Green, say your name for the record, please.
There she is. I have before me a plea form that she's going to plead to retail fraud in the 2nd degree, the 1-year offense. And there is then an agreement that the prosecutor will recommend sentencing under HIDA.
That's correct, Your Honor. That is
All right,
correct.
that's the full understanding. All right, very good. And Ms. Green, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record, please.
Simone Green.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the 2nd degree. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The court has to advise you that if 3 times the value of the property taken, if that's greater than $2,000, that would become your maximum fine. You understand that, ma'am?
Yeah.
All right. And understanding that, do you still wish to plead guilty?
Yes.
And ma'am, you're going to have to get someplace stable. All right. And stationary. So understanding all of that, do you still wish to plead guilty, ma'am?
Yes.
And to that charge, how do you plead?
Guilty.
Say that again, because you're muffled.
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
And you understand that, well, you signed an advice of rights form, is that correct?
Yes.
Do you have any questions regarding any of the rights on that form?
No, sir.
You understand that you're not having a trial, that you're waiving or giving up all of the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Ma'am, are you still there? She froze. Oh, she's back. Ma'am, has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
October 25th, 2024, at the location of 3749 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, What did you do at the Target store that makes you think that you're guilty?
I did a skip scan.
Say that again.
I did a skip scan.
You skip scanned items?
Yeah.
Yes?
Yes.
All right. So you went to the register with items and some of the items you did not pass over the scanner. Is that correct?
Yes.
And the store was open to the public at the time?
Yes.
You didn't have anybody's permission to take those items or to not pay for those items, did you?
No.
And these items that you didn't pay for or skip scan, these were items that were offered for sale by Target?
Yes.
And the total amount of the items that you skip scanned, was that in excess of $200?
Yes.
Ma'am, if I accept your plea, if between the time of plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, the court does have to advise you that you would not be entitled to any sentence recommendation or evaluation, and the court would not be bound by that. And you would not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant?
People are satisfied. Satisfied.
Court will accept the defendant's plea of guilty in this case. Defendant is referred to probation for a pre-sentence investigation and report, and determination of HIDA. Sentencing in this matter will be December 22nd, 2025, 9 a.m. And I do not have probation. Oh, I do. I do have probation intake. All right, ma'am, you're going to have to wait on the line. We're going to put you into a breakout room with probation, my probation department, and we'll begin the sentencing process. You understand that?
Yeah.
All right. Thank you. Bond continue. Court calls the case. People versus Maya Hines.
Hines, I believe, called in. She was having some difficulty with this morning.
Do you have her last 3 digits? Because I have 2 on here.
243.
We do. All right.
And
Miss Hines?
Yes,
All right, state your name for me.
Maya Hines.
All right, she's here.
We are requesting an adjournment. We requested some media from the people. That seems like so we just want to do that.
Adjourn this matter to December 17th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Calls case People versus Wilmer Hudson.
Ashley Phelps for the people.
Oh. Sir, what's your name?
My name is Wilmer Hudson.
All right. Sir, this is an arraignment. You are before the court on a complaint that alleges, as soon as I have it in front of me, on or about May 5th, 2025, at the location of Ellsworth Road near Stone School Road, Pittsfield Township, Washtenaw County, State of Michigan. It alleges the offense of attempted resisting and obstructing a police officer. Do you understand the nature of that charge, sir?
No.
Okay, I'm not asking whether you did it. I'm just asking, do you understand what you're charged with?
No, I don't.
All right, here we go then. Complaint alleges that on May 5th, 2025, at the location that on that date, at the location of Ellsworth Road and Stone School Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did attempt to commit the following listed offense, and in an attempt thereof, did act toward the commission of that offense, but failed in the perpetration of that offense and was prevented in the execution thereof. The offense that they're talking about is that you attempted to assault, batter, wound, restrict, obstruct, oppose, or endanger Officer Derek Monastir, a police officer with Pittsfield Township Department of Public Safety, that the defendant knew or had reason to know was performing his or her duties. You understand now what you were charged with, sir?
No, not really, because I was at work.
Don't care whether you were at work.
And I was
Do
at
you understand that you were charged with an officer attempting to try to conduct their duties, and it is alleged that you interfered and or resisted in the officer doing that? Again, sir, I'm not asking whether or not you did it.
Okay.
Do you understand
Oh, yeah, I
what you
understand.
are charged with?
Yes, I understand what
You
you're saying.
understand what you're charged with?
Yes, sir.
That is a misdemeanor. It is punishable by up to 1 year incarceration, a $1,000 fine plus court cost. Do you understand those maximum penalties?
Yes, sir.
First question I have for you is, do you wish to be represented by an attorney?
Yes.
This is a public defender case.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Hudson. Will waive formal reading, stand mute, and request another pretrial date.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea.
Yes.
Pretrial in this matter will be adjourned December 3rd, 2025, 9 a.m., or as your invite indicates. Defendant's bond in this case will be set as a $10,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon or ammunition. I will also indicate there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. Do you understand all of that, sir?
Yes, sir.
Thank you. Court calls the case of the People versus Devontae Johnson.
Ashley Feltus for People. Public Defender Natalie, on behalf of Mr. Johnson, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Devontae Johnson.
You got it? Okay.
Thank you, Your Honor. I'm asking for an adjournment. I believe we are very close to a resolution. I need to have another conversation with my client.
You guys have to talk out there because I can hear the whole conversation. Turn this matter to December 17th, 2025, 9 a.m. Bond continued. Thank you, Mr. Johnson.
Thank you.
Court calls the case People versus Alicia Calloway.
Feltus for People. Public Defender Natalie Pavin on behalf of Ms. Calloway, who's present via Zoom. Ma'am, can you please unmute and state your name for the court?
Alicia Calloway.
Got it. You got it.
Thank you, Your Honor. To be candid, we had, your defense had planned next week on this matter for a final settlement conference. However, I did receive an update from my client this morning that she is going through some family trouble and is would be unlikely to be here in person today. So to that end, I'd be asking for an adjournment past the December 3rd date.
Turn the matter December 17th, 2025, 9 a.m. Bond continued.
Thank you.
All right. Thank you. Thank you, ma'am.
Thank you.
Court calls the case People versus Lerone Kelsey. Lerone Kelsey. Oh, there.
Yes, Your Honor, I'm here.
Okay, I'll need you someplace stationary.
I am.
All right. You.
I'm sorry to interrupt. I don't know if there was I don't know what happened, but we are appointed to this case.
You are. This is not an arraignment.
I don't know why, it does show it was scheduled for arraignment. I don't know why. There was a warrant that was recalled. Maybe the clerks intended to schedule.
Yeah, okay. This is the pretrial. I set the pretrial for today. I can see my writing. I don't know why. I don't know why it says it.
Sorry then to interrupt.
No, not a problem.
Assistant Public Defender Laura Kearney on behalf of Mr. Kelsey. So Mr. Kelsey, we have a resolution. Mr. Kelsey is going to be transferring his case to the 36th District Court Sobriety Court.
Okay.
We just have some paperwork to get together. He was not available the last couple days to get that available or together. So I'm hopefully asking for one last adjournment so we can get this done.
Will we have to get everything done by the 3rd, or you need the 17th?
I think the 3rd should work.
All right. Sir, I'm going to adjourn your case to December 3rd, 2025, 9 a.m.
Hey, Your Honor, I think I got another court date around that time frame. The 3rd, you push it like the 4th or the 2nd?
I don't schedule that way.
I think the issue is that the 36th does have their sobriety court on Wednesdays. So we kind of run into
What time on Wednesdays are they doing theirs? I mean,
do you know what time you have court?
They got different days that day. So it could be I'm sorry, I just don't know.
But he's been accepted in.
Yes, I have been accepted in.
Yeah, he has another case that's already in.
So are they gonna, you don't know, are they gonna take the plea, or they're gonna want me to take it?
It seems like they keep it. It seems like they will take the plea on this case too. So it's possible that they could.
So let me do this. I'm gonna adjourn it to the 17th. If everything's not taken care of where he can smoothly go into that, then show up on the 17th and I'll deal with what I gotta deal with on this.
Okay.
Fair enough?
Yes, Your Honor.
Okay,
Thank you, man.
sir.
Okay.
Court calls the case, People versus Noman Khan.
Ashley Phelps, people. It's Public Defender Natalie on behalf of Mr. Khan, who's present too. Sir, please state your name for the court.
Noman Rahman Khan.
Your Honor, I'm requesting another adjournment of this matter. Unfortunately, Mr. Khan states that he has been dealing with some health issues and been in and out of the hospital, and he would like some further time to discuss this case with me as well as.
December 17th, 2025, 9 a.m.
Thank you, Your Honor.
All right. You're welcome. Be well, sir.
Mr. Khan.
Court calls the case, People versus Shannon Kiesling.
Ashley Phelps for the people of both.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Kiesling. State your name for the record, please, ma'am.
Shannon Kiesling.
Thank you.
Same kind of thing going on with this. Like we're getting this.
Same kind of thing going on.
Just these specialty courts are helpful but confusing. So Ms. We're referring Ms. Kiesling to the 14A sobriety court.
Okay, that's easy.
I confirmed with Mr. Well, something happened with the referral form. Mr. Keaton now has it. Ms. Kiesling has to do an assessment. So to get screened, and I'll explain what the next step is to you. So I guess I am asking for an adjournment.
Right. But when did they say when they might have all that?
Because she has to do an assessment, that could take a couple of weeks to get back.
All right, let's do it this way then. I'll adjourn this to December 17th, 2025, 9 a.m. My understanding is, and you might want to find out, right, certainly, and there's going to be no objection from this court, but since it is my colleague, certainly they can take the plea on this case. Okay. So
if she's accepted,
whatever's going to work easier for her.
Okay.
Right? And so if everything gets done, but they want me to take the plea, let Ms. Weidling know. We'll set her on the 3rd if they have everything done, and we'll just take the plea.
Okay.
All right.
Okay.
Let's get her moving ahead.
All right. Thank you.
All right.
Thank you.
Thank you, man.
Okay.
Court does call the case of the People versus Lindsay Kohler.
Ashley Phelps for the people. Ms. Kohler, who's present via Zoom. If you please turn your hearing on and I need to state your name for the court.
There we go. There we go. Okay. Hi, Lindsay Kohler.
Hi. Hello. All right.
Hi.
What are we doing?
Thank you, Your Honor. I have two requests. The first would just be, the last pre-trial was adjourned for Ms. Kohler to complete an assessment with her current therapist. Unfortunately, that it's not going to work out. So we're asking for another adjournment so she can complete one through Ron Schwartz for consideration of an offer. Then I have a brief request as to Ron when appropriate.
Adjourn December 17th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. I did already speak to this about this with the people. Ms. Kohler is requesting to travel to Tennessee and Florida from November 24th.
Both of them?
Yes.
Why?
Because she is helping a friend who lives in Tennessee move. They have a garage van and they're trying to take it out of the garage. What she told me. So it sounds, she's being a good Samaritan, helping her friend move, maybe make some.
So it's actually, if you don't mind me speaking for a second here, I have had a van in a garage for a while now. It has been fixed, but I have not been able to get it out. So my friend is going to pay to get the van out and I will help them move from Tennessee to Florida.
Okay, all right.
It's a trade. It's helping.
No, I got it. I got it.
Yeah, it's kind of a really sweet opportunity. I've been waiting for this van to get back this van for a little while now, and I'm very excited. I'm rolling really well on it. Thank you.
Very good.
Thank you.
All right, then what I will indicate is, defendant, do we have a time frame as to when this is all going to happen?
Yes, Your Honor. She says she's asking to be allowed to travel through December 10th. She might be back sooner than that, but the latest would be the 10th.
From now through December 10th?
Oh, sorry, November 20th.
November
24th through December 10th.
That was in high hopes. If everything goes smoothly, in high hopes from the 24th.
All right. I'll indicate defendant may travel to Tennessee and Florida between the dates of November 24th, 2025 and December. Well, it's like one thing you may have to do is stop drinking. Have you seen the bond violation report, either of you?
I'm showing it to Mr. Byrd right now. We did discuss the case earlier and I didn't realize that Mr. Mack had a bond violation. So I was just seeing it right now for the first time. I apologize, Your Honor.
And honestly, Your Honor, to be truthful with the court, Ms. Wiley sent me the bond violation on November 17th.
Right, when we, I think when we got it.
And I believe, I thought it was for a different client and read it for a different client that I have tomorrow. I didn't discuss the bond violation with Mr. Mack. I apologize for that confusion on my part. If we could just address the violation at the next hearing.
I'm not doing that. I mean, because, and I'll be very frank as to why. I mean, first of all, he is here on a drinking and driving case where he was arraigned on October 29th, 2025. So basically the end of October. And then by the 16th, about 2 weeks later, I've got a test of 0.08, almost a 0.9. And then on that test, he failed to retest every 15 minutes as required by the program. And then we also have before that certain periods where he just didn't test. They've also called him on the 17th, realizing this was created on the 17th, so there may be a call, may not be, about his positive test, and to have him come report in for an ETG. They left him a voicemail. It looks like they have not, it's not called back. And I did not, Ms. Feltes, I did not do the arraignment. Do you have the BAC for him?
0.177. And I'm reading a report right now, if I may, Your Honor.
Yes.
To the court. This is from the section entitled Traffic Stop from Pittsfield Township Police Report number 231282. Traffic stop, once I activated my emergency lights, the vehicle east on Ellsworth with its left turn signal, which appeared to me the vehicle was waiting to pull into the Mount Bellion Park. When the driver attempted to turn into the park, the driver had driven too far east of the driveway to make a right turn to miss the curb in the snowbank in a U-turn fashion. The driver pulled into the park where it came to stop, and I was able to make contact with the driver. So there was bad driving by the officer as well. I'm double checking out priors right now. I don't think he has them.
So
Prior,
Hmm?
2010 prior to I. To the
2010.
2010, so it's too old to be a second, but this
Got
is a
it.
second.
So he's got a prior.
Your Honor, respectfully, I do understand my client hasn't followed the bond conditions given to him. The one thing I like to say is alcoholism is a disease. It is a disease, and we place people on bond and conditions upon them, expecting them to be able to cure that disease immediately due to the fact that they caught a case. I do understand that's what's expected. That's what's expected of people, but some people have more difficulty. Some people have more difficulties than others at that. I would ask that you at least allow Mr. Mack one more opportunity to prove to this court that he can take control of that alcoholism and take control of his life.
At the expense of having him drink again and potentially hop into a vehicle and kill somebody?
Well,
I don't think so.
Is there any way possible we could put an alcohol tether on him and a no driving?
I gave him a sober link that he had to blow into. He didn't comply with the testing requirements on that for 2 occasions. And then on the next occasion, on the 17th, he's gone basically about 15, 16 days. And he's got effectively 3 different well, 4, because he's got 2 periods of missed test where he didn't take his test. He then has the positive test, which would be the 3rd violation. And then his failure to take retest after the positive test is another violation.
Can I just ask my client if he has any explanation to this?
One test that I was doing, I had overslept, missed my time period, but with the retest, I just blow it and pay attention to how to do the retest. Because I just set it down and put it back into the box.
That's not.
Does he want a hearing on this, or does he want to admit to the violation? He's got his choice.
Do you admit to the violation, or do you want to hear it? He wants to admit to the violation. He wants to take responsibility for actions, Your Honor.
I will adjourn this matter out to December, the pretrials in both of these cases to December 3rd, 2025. Anything you want to, and at that time I may sentence him on the violation, but I've got to try to figure out something about this individual because he's not able to make it 14 days before he's drinking, and then he's just not cooperating in the program at all.
Your Honor, respectfully, I would just ask if my client could stay out of jail until that 12/3 court date. He's going to still have to adhere to the same bond conditions. There might be better bond conditions that we could tailor to help Mr. Mack through this situation and help him to get over the problem that he has. Obviously, he does have a problem. Obviously, he's got a grip on him. But as I stated earlier, when people have these type of problems, which I believe is a disease, honestly, when people have these type of problems, they get arrested, they get arraigned, they come to court, they automatically get these bond conditions, put on them with the expectation for them to stop. And I understand why the courts had that expectation, because we have a responsibility to protect the community. But I do believe there's less restrictive bond conditions that we could tailor to help address the problem with protecting the community, and also allowing and helping Mr. Matt to get through this situation, because essentially that's what the court's trying to do, is rehabilitate in this matter. So, which I'm not admitting to guilt yet with the case, but I'm just saying, if we could allow him to stay out right now. You are employed, correct?
You want me to let him, after he can't make it 14 days, you want me to let him stay out with the potential of consuming alcohol, getting behind the wheel, to go through the weekend where the most alcohol in this country is consumed, that being Thanksgiving weekend? That's what you want me to do?
I would like you to put an alcohol tether on him with a no drive.
And all that's going to do, I get what you're getting at, but all that's going to do is tell me he's been drinking. I already know that. So I've adjourned it out to the 3rd at 9. He admits to the violation. I'll deal with how I'm going to sentence him on the violation at the pretrial. But at this time, the defendant's bond is revoked and is remanded to the Washington.
Thank you. Yeah.
Thank you.
And you and your honorable court have a great day.
You do the same. Court does call the case, People versus Rodney Lilly.
National Office for the People. This is the public. On behalf of Mr. Lilly, who's present on Zoom. Sir, can you please unmute and state your name for the court?
Rodney Lilly.
Thank you, sir.
Thank you.
Your Honor, I did speak to the people regarding this and did ask for a civil infraction offer. It is my understanding that Ms. Lonnie Phelps reached out to the trooper involved to get his input, or her input, I believe. I would ask for a brief adjournment for that.
December 3rd, 2025, 9 a.m. Thank you, Mr. Lilly.
Thank you.
Court calls the case, People versus Elizabeth Lohman.
People. This is an arraignment, no counsel. And I do not have her check.
She here? No. Lohman, issue an order to show cause for failure to appeal. Court calls case, People versus Adam Martinez.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Martinez. Martinez, state your name for the record, please.
Adam Martinez.
Your Honor, we are requesting an adjournment. Mr. Martinez is also interested in the Fort Kennedy sobriety court. So I'm just asking for some time to get him a screening assessed.
December 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus Clyde McLean.
Ashley Phelps. Assistant Public Defender Natalie Tate, with on behalf of Ms. McCain, who should be present on Zoom, but if she.
Yes, she is. Ma'am, state your name.
Lady McCain.
Lady.
Your Honor, I did speak to my client regarding this, and we're asking to set it for a final settlement conference.
Jury final settlement conference will be set December 5th, 2025 at 9 a.m. Jury selection, if necessary, will be December 8th, 2025 at 8:30. Both of those proceedings are in person. Bond will continue. Thank you, ma'am.
Thank you.
Court calls case of the People versus Jason Olson.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Olson. State your name for the record, please.
Jason Olson.
Thank you.
Your Honor, I'm asking for adjournment for plea negotiations. please.
You've been getting your way all day. Really bothered.
I think my way's pretty good.
What?
Usually, my way's pretty good usually.
All right. How much time you think by the third?
I'm hoping by the third I've presented what we would like to the people, hoping that they also go with my way.
I'll give it a chance. Let's see if we can work something out on that. I'll adjourn this to December 17th, 2025, 9 a.m.
Thank you.
Thank you, Your Honor.
Room for resolution. Thank you, sir. Court calls the case of the people versus, is it Gina Randolph?
Assistant Public Defender Natalie Pate with on behalf of Ms. Randolph, who should be present here, or is present via Zoom. She texted me a screenshot from the waiting room. Ma'am, can you please turn your camera, unmute your name up for the court?
Ajane Randolph.
Thank you, Your Honor. I'm requesting a brief adjournment. I did get confirmation from the people this morning that the previously spent offer is still open. So I need to discuss that again with my client.
I'll adjourn the matter to December 3rd, 2025, 9 a.m. Continue.
Thank you.
Court calls case people versus Jared Roberson.
Votes for the people. And Assistant Public Defender Natalie Pate on behalf of Mr. Roberson, who should be present via Zoom. Sir, please unmute and state your name for the court.
Jared Roberson.
Thank you. There is a civil infraction resolution in this case. The people have offered the civil infraction of no proof of insurance, and it is my understanding my wants to accept that offer today.
That's correct. We got 257328 as count 2, no proof of insurance.
Sir, Mr. Roberson, do you admit responsibility on March 6th, 2025 at the location of I-94, Pittsfield Township, that upon the request of a police officer to provide insurance, you failed to provide proof of insurance?
Yes, sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $155. When can you get that paid?
As soon as possible. 2 weeks.
Okay. Get it paid by December 12th, 2025.
Okay. I appreciate it.
Thank you, sir.
Thank you.
Court calls the case of the people versus Miles Rowe.
Good afternoon, Assistant Public Defender. Mr. Rowe, state your name for the record, please.
Miles Rowe.
Governor, we have come to resolution and you should have a plea form.
Negatory, Ghostwriter. I have nothing.
Well, we have come to resolution. I'm sorry about that. I thought I sent it in.
Did we get one?
I'm looking, I don't see one, but I am looking.
Well, Your Honor, we have it ready to, Mr. Rowe, the agreement is for him to plead to an OWI. It'll be a guilty plea. I can.
To an added count 2?
Yes. I can print it out now, or go take it.
To an OWI first, the 93,500.
Yep, to plead to an added count 2 of operating while intoxicated, first offense 257-625, 93-day misdemeanor, and or $100 to $500 fine, and or 300. It says 36. It should say 360 hours of community service. Apologize for the typo. To dismiss count 1, operating with high BAC. There are no further agreements.
So, Mr. Rowe, this isn't your fault. This is my fault. It's just the paperwork we discussed yesterday. My email was not sent or lost. Probably not sent.
All right. Well, get the plea form to Ms. Widely, and then I'll take his plea. He's expecting that should happen. So, but here's the problem. I don't have did you have an advice of rights?
Yes, I also sent a signed advice of rights form to Ms. Wheeler.
Okay.
I was prepared there.
Huh?
I was prepared in that way.
So you sent those too?
I sent them both just now, yes.
Sir, please raise your right hand. I don't know why I like her. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
State your name again for the record, please.
Miles Rowe.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days in jail, up to a $500 fine plus court cost. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services. Do you understand all of that, sir?
Yes, sir.
And understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You had signed an advice of rights form, is that correct? Or gave your attorney permission to do so?
Yep.
Do you have any questions regarding any of those rights?
No, sir.
All right. Under paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights that are contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
On the date of November 16, 2024, at the location of 2455 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
I couldn't tell you, and way too much.
Okay. All right. Were you stopped by the police or was there an accident?
I was parked, but I had hit a pole beforehand.
Gotcha. All right. Did the police arrive?
Yes, I believe so.
All right. And at some point, were you taken to the hospital?
Yes, sir.
And were you given a blood test?
Yes, sir.
And are you disputing that the result of that test was a 0.224?
No, sir.
All right. Do you have any reason to dispute those test results?
No, sir.
All right. Sir, if I accept your plea, if between the time of your plea and the time of your sentencing, you commit misconduct as defined by the Michigan court rules, the court would not be you would not be entitled to, nor would the court be found by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promise, threats, or other inducements that have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Or satisfied. Satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Oh, I got the paperwork, Perry. All right. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be, say it again, December 22nd, 2025, 9 a.m. or as your invite indicates. Bond with its conditions will continue. And do I have one? Yes, I do. All right. and bond will continue. Sir, I'll need you to wait online. We're going to put you into a breakout room with my probation department so we can get that process started. Okay, sir?
All right, thank you.
Thank you. Court calls the case, People versus Ethan Rhymes.
Assistant Public Defender Natalie Pate with on behalf of Mr. Ryan, who's present on Zoom. Sir, can you please unmute and state your name for the court?
Ethan Ryans.
Where is he? Okay, there he is. All right. I do this time have a plea form. Plea form indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, the 93-day offense. Upon his successful plea to that charge, count one, the operating with a high BAC would be dismissed. That is the court's full understanding of the agreement.
Yes, sir. That is correct.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
State your name for the record.
Ethan Ryans.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir, I do.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir. My attorneys have signed it for me.
Okay. You have any questions regarding any of those rights?
No, sir, I do not.
All right. Under paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes, sir, I do.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir, that is correct.
And also because you believe that you're guilty of this offense?
Yes.
On November 1st, 2024, at the location of Silver Spring Drive in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes.
What did you have and how much?
Cavassier, probably about a fifth, quite a lot.
Were you stopped by the police or was there an accident?
I had hit a few trash cans and someone had called the police.
Pardon?
I had hit a few trash cans and someone had called the police.
So there was an accident?
Yes, sir.
Did the police arrive at some point?
Yes, sir.
Were you ultimately arrested?
Correct.
All right. Were you taken to the hospital for a blood draw?
Yes, sir.
Were the results of that blood draw a 0.23?
That is correct.
All right. You have any reason to dispute those blood test results?
No, sir.
Sir, if between the time I accept your plea and the time of sentencing, you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir, I do.
Counsel aware of any other promises, threats, or other inducements which have led to this plea?
No.
And have I complied with the court rule?
Or satisfied? Yes.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for a alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be December 22nd, 2025, 9 a.m. Defendant's bond with its conditions will continue. Mr. Ryans, I need you to wait for a moment. we're gonna put you into a breakout room with my probation department so that we can begin the sentencing process. All right, sir?
Yes, sir. Thank you so much.
Thank you.
Thank you, Mr. Lyons.
Court calls the case of the people versus Erika Scott,
Actually, felt this for the people.
if I'm pronouncing it. She's not checked in. Unless you in order to show cause. Court then calls the case of people versus Robert Stevens.
Actually, felt this for the people. Under Natalie Pate, former Stevens.
Hello.
Please state your name out for the court.
Yes, this is Robert Stevens.
Okay.
Thank you, Your Honor. I believe we are pretty close to a resolution. I'm going to have another conversation with my client and get back to the people regarding one piece. So I would be asking for an adjournment for a couple or two to 3 or so weeks.
December 17th, 2025, 9 a.m. bond continued. Thank you.
Thank you, Your Honor.
Court calls case people versus Martia. What's that? Stewart.
She felt this for the people. This is a show cause for not hearing.
Are they here? Stewart? No response. Bench warrant. I already issued a bench warrant. Did they clear it? There's a second non-appearance. Well, it doesn't matter. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $7,500. I'll give a 10% privilege. That warrant will issue immediately. This one is not to be canceled. Court calls the case of the people versus Angela Stoker.
Actually felt this for the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Stoker. Ms. Stoker, state your name for the record.
Angela Stoker.
Your Honor, we're requesting a final settlement date, please.
Nope.
Please. Pretty please.
She says, please. You've been getting your way all day, Parody. That's why.
This seems like a simple request, right? This is faster than a
You're right.
plea.
This one is not a bother. All the other 10 that you asked for today have been. Good.
Fair enough. But I'll do it for Ms. Stoker.
Okay. Jury final settlement conference will be set December 5th, 2025 at 9 a.m. Jury selection, if necessary, will be set for December 8th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
All right, thank you.
Thank you.
Court calls the case, people versus Jared Taylor.
People. Assistant Public.
Yeah, yes.
He's dialing. Mr. Taylor,
Hello.
can you state your name?
I can hear you.
State your name.
Jared Taylor.
Thank you.
Your Honor, may Ms. Elton and I briefly approach?
Yes.